Good evening, ladies and gentlemen. Would like to call the Planning and Zoning meeting to order for this evening, January 28th. And we will start with the roll call. Madam Secretary.
Chairman Francis.
Here.
Mr. Chambers.
Here.
Mr. Delacus.
Here.
Mr. Giulicis.
Here.
Mr. Stavropoulos.
Here.
Ms. St. Arnold. Here. Mr. Vinson.
Here. Okay, thank you. Okay, we were catching up on some of our minutes, and we have first the October 15th minutes. Would entertain a motion to accept the minutes of the regular session October 15th.
I'll make a motion that we accept the minutes as stand for October the 15th.
Second. Okay. Roll call.
Mr. Chambers.
Yes.
Mr. Delacus.
Yes.
Mr. Giulicis.
Yes.
Mr. Stavropoulos.
Yes.
Ms. St. Arnold. Yes. Mr. Vinson.
Yes.
Chairman Francis.
Yes. Thank you. And we will move on to the November 19 minutes. Motion approved. Second. Okay. Any discussion? Roll call.
Mr. Chambers.
Yes.
Mr. Delacus.
Yes.
Mr. Giulicis.
Yes.
Mr. Stavropoulos.
Yes.
Ms. St. Arnold. Abstain. I wasn't here. Mr. Vinson.
Yes.
Chairman Francis.
Yes. Thank you. Okay, at this time we will have the quasi-judicial announcement by Mr. Yakovon, our attorney.
The next two items on the agenda are quasi-judicial hearings. They are quasi-judicial proceedings where the board acts in a quasi-judicial capacity by law. It is the board's function at this hearing to make findings of fact based upon the evidence presented at the hearing and apply those findings of fact to previously established criteria contained in the Code of Ordinances in order to make a legal decision regarding the application. Before it, the board may only consider evidence that the law considers competent, substantial, and relevant to the issues arising from the application and the applicable code sections. If that evidence demonstrates that the applicant has met the criteria established in the Code of Ordinances, the board is required by law to find in favor of the applicant. By the same token, if the evidence demonstrates that the applicant has failed to meet the criteria established in the Code of Ordinances, the board is required by law to find against the applicant. The parties to this hearing are the applicant and the city is represented by city staff. There may be persons, organizations, or groups that qualify as interveners. Persons or groups that qualify for intervener status can participate in the hearing as a party. A recognized intervener may examine witnesses, present evidence, and make arguments to the board. For a person to be granted intervener status, the person must demonstrate to the board that he or she will suffer an adverse effect as a result of the quasi-judicial decision which exceeds in degree that which may be suffered by the general community. Intervener status may also be granted to an organization or group or to the representative of an organization or group of persons who have a substantial and compelling interest in the matter under consideration if the organization or group can demonstrate that substantial and compelling interest and that it is prepared to present competent and relevant evidence that would be of significant assistance to the board in making its quasi-judicial decision. In a few minutes, the chairperson will give persons, organizations, or groups desiring intervener status the opportunity to make their request. There is an established procedure that will be followed at this hearing. All witnesses must give their testimony under oath. All persons testifying at the hearing must give their names and addresses for the record. All testimony and questioning at the hearing must address matters that are relevant and material to the issues under consideration. City staff will go first and present its evidence. The applicant and any recognized interveners will have an opportunity to cross-examine city staff. The applicant will then present its witnesses and evidence, and city staff and recognized interveners have an opportunity to cross-examine the applicant's witnesses. Recognized interveners then have an opportunity to present their evidence and witnesses, and city staff and the applicant have an opportunity to cross-examine the intervener's witnesses. Absent unusual circumstances to be determined by the board, a party's statement and presentation is limited to 10 minutes. At that point, we proceed to the public comment portion of the meeting. Members of the public opposing the application will have an opportunity to present testimony. After all members of the public opposing the application have concluded, members of the public in support of the application will have the same opportunity. Each member of the public is limited to 4 minutes of testimony. A member of an organization or group granted intervener status who testifies as part of the organization or group's presentation forfeits the right to speak at the public comment portion of the meeting. During the public comment portion of the meeting, members of the public present at the hearing may donate their time to a speaker to extend the speaker's time, but in doing so, the person donating the time forfeits his or her right to speak. Each donation shall extend the speaker's time an additional 2 minutes. In no event shall the speaker's time be extended beyond 10 minutes of total speaking time. Following public comment, the applicant, city staff, and recognized interveners will have an opportunity to present rebuttal evidence and make a closing statement, argument, or summary. The applicant will go first, followed by city staff and any interveners. Absent unusual circumstances to be determined by the board, a party's closing statement and rebuttal evidence will be limited to 10 minutes each. Following this, the board will consider the matter. I would ask all persons who intend to testify, which means walk up to that microphone and say anything, at this, in these next 2 agenda items, to raise your right hand and take the following oath. Do you swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? All right. Thank you. Mr. Chairman?
Thank you very much. Okay, our first application is application 11-60, Valeris Partners, and at this time, we will hear staff report.
We need to find out if there are any interveners.
I'm sorry. I apologize, Mr. Coburn. Please come up to the lectern and give a name and address, please.
Good evening, everyone. I'm Mary Coburn. I'm an attorney here in Tarpon Springs, 15 East Orange Street, Tarpon Springs. I am here seeking intervener status on behalf of 5 clients who would be impacted. They are Kitsos Land LLC, Naomi and Sarantis Kitsos. They own the property right next to the applicant's property on both sides. So that would be next to Dimitri's, where there's a lot there, and then on the other side of this lot where there's Spongerama, and you have they have a Yanni's restaurant and a boat line on a dock there. That would be the first client. Then there's Mykonos Restaurant, which is across the street, Andreas Salaveras, and you also have Dimitri's on the water. Andreas Salaveras is also here for that. Mr. Dimitri cannot be here. Athena Sardulius for Tarpon Sponge, Inc. That's a retail curio shop in the Sponge Exchange. Gift World, I also represent Michael Tsambanides of Mihalis, Inc. And Rio de la Portis, who's here, Tarpon Shell Shop and Tropical Breeze. So the basis for our intervener status is that there would be aggrieved parties that have a higher degree of injury versus the public, and also their location on Dedekinis Boulevard, which is adjacent and would be affected, their property values would be affected directly.
Mr. Chairman, I move that Ms. Colburn's clients be granted intervener status.
Second. Okay. Is there any discussion?
Yes, please.
Mr. Iacobone, I'd like to ask you first, to acquire intervener status, I believe it was that they had to show compelling interest above and beyond what the general public would suffer. Can we just maybe clarify that? Is that the case?
Yes, that's the standard that's used in most of the statutes that the person must demonstrate that they will suffer an adverse effect as a result of the decision which exceeds in the degree which may be suffered by the general community.
Thank you. Ms. Coburn?
Yes.
I will support the motion. However, I must say that you must present to us evidence that
Absolutely.
indicates your clients are harmed more than the general public. Because I don't know if you're familiar with our intervener status last time, but I must say your arguments last time were not compelling as far as indicating their degree of harm.
Well,
So that's my statement. That's all. Not needing a response. Thank you.
Is there any other discussion? Roll call.
Mr. Chambers?
Yes.
Mr. Delacus?
Yes.
Mr. Gialusis?
Yes.
Mr. Stavropoulos?
Yes.
Ms. St. Arnold? Yes. Mr. Vincent?
Yes.
Chairman Francis?
Yes. Okay, thank you.
thank you.
Please take a seat, Ms. Coburn. Okay. Now we will get to the staff report. Mr. Chairman.
Thank you, Mr. Chairman. This application is 11-60. As stated in your backup, the applicant has voluntarily chosen to amend the plan and have it looked at again by the Planning and Zoning Board. If you recall, at the December 17th meeting, the board reviewed an application for 21 kiosks at this property. The applicant has reduced that number down to 6. The location is 590 Bilderknees Boulevard. And I'll go ahead and hit the high points of the staff report. We've added additional information based on the change in the plan, as well as some of the items that were brought up at the December 17th meeting. Just quickly, the property is a little less than 19,000 square feet and has a small existing commercial structure with an overhang and off-street parking area. The applicant operates a sponge dealing business out of the structure, and sponges are sold in an outdoor display area. At the front of the property, the applicant was also granted approval to sell eucalyptus oil from another small retail kiosk on the property. The applicant is proposing to keep the commercial off-street parking lot and add a maximum of 6 retail kiosks along the front property line. The applicant's plan would be a retail operation of outside vendors that will sell consumable goods to the public. The plan, you have that clearly spelled out in your backup, consists of professionally designed or prefabricated kiosks, the size of those which would not exceed a 10 by 10 foot area. That's shown as attachment A, landscaping, and the removal of the existing asphalt and replaced with a stamped concrete pattern for better aesthetics. It's a single-phase project, and they are asking for a 3-year time frame to complete those components. The applicant has also agreed to grant the city a minimum 10-foot landscaping easement along the front property line. This would allow the city to install appropriate landscaping to be consistent with some of the items that have been discussed as part of the Sponge Docks Improvement Project. Lastly, the subject property is underutilized, and the conversion to these types of use is consistent with the vision of the Sponge Docks for shopping, dining, and the working waterfront are combined to create a unique waterfront experience. As far as standards for review, I will go ahead and briefly go over the criteria, and this was what we as staff used to evaluate the application. Criteria 1 deals with requirements in the Land Development Code. 2 deals with the appropriateness of the use and its compatibility with existing and planned uses in the area. 3 deals with the city's comprehensive plan. 4 has us analyze any adverse impacts to the environment or historical resources associated with this application. 5 evaluates any adverse impact it would have on adjoining property values. 6 deals with any adverse impacts or the capacity of the city of Tarpon Springs to provide available public facilities, which includes transportation, water and sewer service to the property, solid waste, drainage, recreation, education, fire protection, library service, and other similar public facilities. And 7, deals with the efficient and orderly development and its impact upon growth patterns and the cost of the city to provide public facilities. Under standard for review for criteria 1, obviously it's a conditional use in this part of Tarpon Springs. It's an outdoor operation with 6 kiosks as shown in the attached conceptual plan. The applicant has provided examples of kiosks from Yoder's handcrafted gazebos. The brochure shows different styles and sizes of structures. However, the applicant will be limited to kiosks no larger than 10 by 10 in size. Questions in the areas of plumbing, electrical, mechanical, wind loading, etc. were raised during the December meeting. Those questions are not pertinent to the matter, nor are they of the purview of the Planning and Zoning Board. The city's building official administers the building code, and these types of details will be provided once the applicant has applied for a building permit. It is staff determination that the applicant's conceptual site plan is in conformance with the requirements of the Land Development Code. 2, there are numerous small retail operations surrounding this property. I'm sure you're all familiar with those. For example, Island Tours, Nick's tobacco operation, the Sponge Factory, Mykonos, Dimitri's, etc. In addition, the city will soon begin engineering design on the Sponge Docks Improvement Project. The main objective is to improve the aesthetics along the corridor. A lot of what we heard was the walk in this area of Dodecanese is extremely unfriendly to pedestrians, and there was a lot of discussion amongst the stakeholders about finding ways to provide additional shade and comfort to the tourist population. The rendering shows almost a finished product, if you will, of the kiosks, as well as the landscaping that would be planted should the conditionings be granted. Furthermore, attachment B shows a variety of kiosk-type structures that exist throughout the Sponge Docks. These proposed structures are consistent in style, size, and use with the proposed kiosks. The staff's determination that the applicant's request is consistent with the city's redevelopment goals. Criteria 3 is talks about the special area plan and the smart code for the Sponge Docks and community redevelopment area. And you have the vision statement there in your backup. The goal of the plan was to create an environment that encourages the redevelopment of underutilized properties in the Sponge Docks and the CRA. The character district will continue to support the working waterfront. And the tourist trade is one of the themes in that statement. We feel that the requested redevelopment is consistent with those goals, objectives, and policies in the city's comprehensive plan. We determined that this application will have no impact on environmental or historical resources. This proposal will have a positive impact upon neighboring property values. The city of Tarpon Springs has the adequate resources to provide all services to the property, and the applicant's request, as conditioned, will have a positive impact upon the growth patterns of the Tarpon Springs area. TRC reviewed the application in late November. You see their comments there in your staff report. Obviously, there is a lot of public correspondence on this item, both primarily in the form of public testimony and comments during the hearing. You see a summary of those in your staff report. You have the staff recommendation from the December meeting as item 6. You also have as item 7 a summation of the content of the discussion during the December meeting. And briefly, I'll just hit things that were talked about. Bathrooms were discussed. Providing water, sewer, and electrical service to the kiosks were discussed. Loading zones, items to be sold, the definition of a kiosk, compatibility, not only with surrounding uses, but with the comprehensive plan and the sponge docks, and CRA special area plan, as well as unfair competition with, bricks and mortar stores. To kind of refresh your memory, the Planning and Zoning Board voted to deny the application by a 4-1 vote. 8 talks about the amendments that have been made to the plan. Again, only 6 open structures along the road frontage are requested for approval at this time. 2, the applicant is requesting 3 years to complete the project, and 3, the structures have to conform to those that are shown on attachment A. For our staff recommendation, we as staff assert that this application has conditions of performance with the requirements of the conditional use approval as set forth in the code, the comprehensive plan, and the special area plan, as well as the SMART code. There is a clear intent to allow kiosks as conditional uses in the sponge docks area. Such uses are, in fact, a desirable transitional use for the surface parking lots that are an eyesore and do nothing to promote local, regional, or out-of-state tourism. I'll hit on the definition in the SMART code as far as the kiosk. It's defined as a booth that may have an open windows on one or more sides operated by vendors selling small and inexpensive consumables such as newspapers, magazines, lighters, street maps, cigarettes, and confections, and the like. This definition does not limit potential vendors to those such items. Rather, small and inexpensive consumables is a subjective description which can describe a variety of items. The applicant will be required to ensure that the vendors sell these sorts of items, which may or may not be similar to those referenced in the definition. If those types of items are not sold in the kiosk, then the applicant will be in violation of the conditional use. These uses may also allow the parking lots to still function as such while using the kiosk along the street frontage to screen those parking lots and provide a continuous pedestrian experience that maintains the interest of tourists and visitors, which again, as I stated earlier, is addressing a common complaint that were expressed during the Sponge Docks Improvement Project public meetings. The staff recommendation is to approve the application subject to the following amended set of conditions. All structures must be prefabricated or professionally designed. No pop-up style tents will be allowed. Structures must be substantially similar to those identified in attachment A. 2, the approval is limited to 6 structures to be placed within the area as identified in the conceptual site plan. 3, all site improvements shall be completed by March 1 of 2016, or the conditional use may be revoked for noncompliance. All landscaping must be irrigated. The applicant must grant the city a 10-foot landscaping and pedestrian easement on the front property line within 30 days of approval of the conditional use. And 6, all other temporary structures / tents on the property will be removed except for the existing permitted structure that currently houses the eucalyptus oil sales. That structure will be counted as one of the permitted 6 structures and will be aligned with the proposed new structures on the road frontage. As far as attachments, you have a photograph of the site. You have a memorandum from the applicant requesting the review of the amended conceptual plan. You have a conceptual site plan showing the 6 kiosks approximately, and the approximate locations, the landscaping, and the other improvements on the property. You have a rendering showing what the proposed kiosk would look like with the landscaping along the front property line. Again, you have the information on the kiosk structures themselves from the manufacturer. You also have photographs of several different types of kiosk-style structures that are currently down on the dock. And then you have your area map, an aerial photograph, your zoning map, and the future land use plan map as part of your package. Are there any questions?
Okay. We'll start with this end. Mr. Arrow, you have questions for staff at this time?
didn't hear what you said. Okay, I didn't think you said that. I have no
I
questions
did-
at this point.
I did say that.
No, it was kind of hard to hear.
I'm sorry?
It's okay, it was a little muffled, it's all right. Yeah.
Mr. Giulustis,
No question.
Mr. Vincent?
Question for either Rodney or Mr. Yakabone. Regarding the easement, is that going to be a perpetual easement that's proposed?
No, it'll be revocable. Because the
Under
applicant,
what conditions and,
on agreement by both parties, because the applicant, we've had discussions with their future plans on the property, and at such time that they, want to redevelop it in a different manner, then, it could be revoked, and the landscaping could be removed for the new development.
do you recall the city ever giving or receiving a revocable easement since you've been working here?
Not in the time I've been here, no.
Thank you. No further questions.
Okay. Mr. Stavropoulos?
Yes,
Go ahead.
question is for Rodney. You had mentioned something about water, sewer connections to the kiosks. Is that true?
Yes, I was referencing that as far as an item of discussion during the December meeting, but again reiterated it has no relevance to the application at this point. It's just purely the conditional use evaluation.
So that I'm assuming there won't be any bathrooms or benches and so forth.
That's correct.
Okay.
No comment.
You have questions, right? You have no questions? Mr. Jalakis?
Thank you. I'd like to follow up on Mr. Vincent's question with regards to the easement, because my concern was if the city's granted a 10-foot landscaping and pedestrian easement and trees are going to be planted there, whose responsibility is it for the maintenance and trimming and all that stuff?
The applicant.
Okay. And as far as the pedestrian easement, is that a separate easement than the landscaping? Maybe that's Mr. Yakabone, because I would think there's two different issues there. And one may want to be revocable and the other may not want to be revocable.
Can you restate the question?
Okay. In the recommendations, item 5 says applicant must grant a 10-foot landscaping and pedestrian easement along the front property line within 30 days of the approval of conditional use. What I'm asking, is it one easement that's revocable, or is the 10-foot landscaping easement separate and that's revocable, and the pedestrian easement is separate and that's not revocable? So I'm just trying to clarify, do they have to be as one? And if not, can they be separate? And can they be both different? In essence, we can give them the landscaping to be revocable, but the pedestrian not revocable. Do you understand, Mr. Yakabone?
Yeah, I understand. I think it would be up to the applicant whether they are willing to give an irrevocable pedestrian easement. Whatever pedestrian ways they have to provide, that they have to provide or required to provide would be whatever is set forth in the SMART code. And so at some point I would imagine the land could be redeveloped. I don't know that any property owner is going to want to give the city an irrevocable easement and effectively limit the size of their property.
And Rodney, without this pedestrian easement, what would they be required to provide as far as pedestrian access up front? Would they have to put there's already a sidewalk.
There's already a sidewalk there.
So there would be no other additional necessary requirements on a standard action. Okay. In the new staff report, page 4, the number 6, the conditional use. Conditional use will not adversely impact nor exceed the capacity or the fiscal ability of the city to provide available public facilities, including transportation, et cetera, and other similar public facilities. I was looking in our code book. Do we have a definition for public facilities and what it is considered? And I guess my basic question, to me, common sense says public facilities would be bathrooms. And I see a nod from Mr. Yacovo.
I agree. If it's a public bathroom operated by the city, it's a public facility.
Okay, thank you. I see we got a little packet here, and there's a chart with the specific functions and use. The board members, it's the little graph one. Okay. Okay, well, it's up on the board, so I'm using it as evidence, but it can be noted that the intervener said she provided the evidence. It's from our codes, and under SDB, when you look, there's kiosk highlighted, and it shows a conditional use. But the second item on that listing says open market buildings, and that is permitted by right. So I guess from staff's perspective, you know, I keep reading open market, yet we have one that says open market building. So what is, in staff's opinion, what do you all consider an open market building?
Defined in the code.
It's defined in the code.
Point of order, Mr. Chairman, can you read the definition of an open market building so it can be entered into the record?
Again, Ms. Coburn provided you a copy of Chapter 6, which is the definitions of the SMART Code, and it defines it as a retail sales establishment operated under a fixed permanent roofed structure.
Okay, here we go.
Which may or may not contain walls, limited to farmers markets, flea markets, food vendors, and the like.
Okay, so if retail operated under a fixed permanent roof structure, which may or may not contain walls, doesn't say anything about the size of the structure, correct?
That's correct.
Okay, thank you. And just for clarification, Mr. Chambers kind of mentioned to me, in our new staff report, where it has the old TRC stuff, just for the record, that's the old TRC recommendation, correct? And that's why it's in there verbatim from previously, correct? In the new report, it's under the TRC.
Mm-hmm.
So I just want to confirm that for the record. It's not new recommendations. That's just what the TRC had agreed to before.
Yes.
Thank you.
I'm good. Okay, I've got some questions. Mr. Chairman, has not the Planning and Zoning Board always considered public safety in applications that require evaluation and consideration by the staff?
Yes, I believe in situations such as this, conditional use gives you, actually all applications, you look at safety and in determining the appropriateness of a use. Yes.
All right. And I know in your staff analysis it states that the wind loading in this application regarding the kiosk gazebo structures are not within the purview of the Planning and Zoning Board. Now, the definition of purview is range of understanding. So, please help me in understanding how the people who are sitting here on this board, who are volunteer, public, private citizens sitting here, would not have it within their purview to be concerned with public safety, since Florida is prone to hurricanes, and these structures are not, we're not talking about real structurally sound structures. So these may become detached and fly around and cause damage or even possibly cause fatalities.
Thank you, Mr. Chairman. Just to clarify, and respond to your question, these structures, while they may be gazebos or smaller type structures, they still will need to meet all Florida building code requirements to get issued a permit.
In the previous application, we had drawings of how they were going to be tied down. That's not present in this amended application. So that leaves me with a question mark. Can you answer that for us?
They will be required to submit plans that are signed and sealed by an engineer registered to practice, licensed to practice engineering in the state of Florida, that will certify that the structures do meet the wind load standard, for example, and all other applicable building codes.
Okay. I would like to put it on the record that I'm concerned about the public safety of this application. I want that so noted in the record. Help me with this one. How are gazebos and outdoor markets defined in the SMART Code and Special Area Plan?
Well, gazebos are not defined. I thought I just read the definition of an outdoor market.
Outdoor market building, not an outdoor market. You read outdoor market building. Is that correct?
That's correct.
Okay. So where is the definition in the SMART Code and the Special Area Plan for a gazebo or an outdoor market?
There is no definition in the SMART Code for those specific terms.
Okay, so in the SMART Code they do not exist. Is that correct?
No, I said they're not defined in the SMART Code.
I have not seen them. Do you have them in your SMART Code?
As I've said the previous two times, they are not defined in the SMART Code.
Okay, they're not in there. I'll look. Okay, now, when you have these different points and standards for review, I want to know how is an outdoor market compatible with other retail establishments? How is it compatible?
Well, that question has been really removed from you. When the council adopted the SMART Code, it adopted these tables, and it said in SPV districts, an open market building is a permitted use. So it's determined by the SMART Code that that's a compatible use.
You said outdoor market building. I'm talking about an outdoor market, because that's what's in the application, is an outdoor market. It says outdoor markets can provide an attractive alternative to traditional brick and mortar stores. It's right in the application.
We don't have a copy of the application, Mr. Chairman.
It's right. This is right here.
That's a staff report.
Okay, it's staff report. That's fine.
Mr. Chairman, just for clarification, I just want to make sure on section 1 of the application, this application requesting conditional use approval for 6 retail kiosks in the SDV Marine Tourist Zoning District. On page 1 of the application, titling what the application is now, as far as maybe the terminology that they might use in there.
It's still in here. Okay. It's still in this. If you read your staff report, you'll find it. It's still in there. Okay. Mr. Chairman, how many outdoor markets do we have in the Sponge Docks at this time?
Again, as I provided to you in the backup, you'll see, and I know most of you are aware there are several kiosk-type structures down there.
Oh, I know. Excuse me, but I'm not asking about kiosks. I'm asking about an outdoor market. How many outdoor markets presently exist in the Sponge Docks? I mean, I want to know.
I don't follow your. You have to.
No, it's a straight question. I mean,
it's
straightforward. I mean, do we have any outdoor markets in the Sponge Docks?
I can tell you that there's structures down on the Sponge Docks where people sell items. Yes, there are. They sell tickets. They sell cigars. They sell snow cones. They sell handcraft jewelry.
Those are individual. That's like an individual kiosk.
I think what he's trying to ask is there anything at the docks that would fall within the definition of an open market building as you have?
No, it's not open market, an open market.
Yeah, but that's the only definition they have in the definition.
I know, but open market is in this, staff report.
But that's not what we are deciding. We're talking about 6 retail kiosks. So that's a defined term in the SMART code. That's what the applicant is requesting. That's what we've done our evaluation on.
6 kiosks turn into an open market. Okay. The other thing is this. If you have a gazebo or a kiosk, and you said that this was compatible with some brick and mortar places, and I'm going to give you some examples because you've mentioned them right here, right under the analysis. That is on page 3. Okay, so you have included that the surrounding properties are a mix of commercial and retail uses to include. Yes, I see the Island Wind Tours, Nick Bobading, and Tobacco King. But you've included Dimitri's on the Water. That's not a kiosk. Mykonos is not a kiosk. Spongerama is not a kiosk. The Sponge Factory is not a kiosk. Elas has 3 restaurants down there. None of those are kiosks. We have Catherine's Linen Shop. That's not a kiosk. Gloria's Gifts. That's not a kiosk.
If I may clarify, the exact reading of that sentence says the surrounding properties are a mix of commercial and retail uses. The staff report does not say that the surrounding uses are all kiosks and list those businesses you referred to.
Well, you kind of lumped them together.
No, I've clarified and given you information on the surrounding uses that surround the subject property.
That's fine. You have your opinion. I have mine. Number 5 here. The conditional use would not adversely affect adjoining property values. Now, which properties do you consider adjoining?
I'm sure we can find a definition in the Standard Dictionary for that. But essentially, what you're looking at are properties that abut the subject property. So to the east and to the west. Yes.
Okay. And that's your definition of adjoining is right next to it?
Yes.
Okay. Now, this, you've stated that this conditional use is not going to adversely affect adjoining property values, but I want to know this. What substantial and competent evidence do you have to prove your analysis?
Well, I think when you look at property values, the appraisers in that profession look at a whole host of factors to determine a property's value. Things like arm's length sales, things like physical improvements that are made to a property that have a monetary value will increase the value of the property. It's pretty common sense to know that once you, for instance, put a pool in at your house, you're spending $35,000, $40,000 on that improvement, and it will you will see an appreciable rise in your property value based on that investment in the property. The way we look at this application is similar to that. They would be spending financial resources to make the improvements to the property, which in turn will increase the value of that property.
It'll increase the property of the applicants. I'm talking about what if you had a mixed-use building and you put it on that property, how would that affect the adjacent, adjoining property?
Obviously, the bigger investment in the improvement to a property, the greater, impact positively that you have on property values. Right.
And you really believe that if we put gazebos there, that it's going to increase the adjoining real estate values?
I believe that if the project turns out like the rendering shows, it will have an increase in the applicant's property value.
That's just your opinion. I have not heard any proof. There's no proof. That's just
We
an
haven't had any
opinion.
testimony yet, Mr. Chairman.
What?
We haven't had any testimony yet. We haven't
Okay.
got to that part.
Okay. Okay, now, number 6, how is this going to have a positive impact on growth patterns?
In our evaluation of the request and the time that we have been here as staff, it's been something that we have looked at as far as ways to provide redevelopment and incentives for these asphalt parking lots. The Sponge Docks has several of them. They're extremely underutilized. They're large tracts of land. We feel that this is a step forward in providing and helping the docks improve itself. Providing a nice aesthetic kiosk operation done appropriately with landscaping and other hardscape improvements will help, and we're hoping it'll help others provide some sort of investment in their own properties. They're not the only ones that own large asphalt parking lots. So what we hope is that this will help spur other development projects on some of those parking lots.
So you want a proliferation of this type of project? Is that what you're saying?
That's not what I said. What I said is that we hope that it will spur redevelopment of those parking lots.
Well, that remains to be seen. Now, you talk about a continuous and interesting pedestrian experience and using kiosks as a screening device. When we were in the focus groups, and I went to every meeting, I never heard of anything like that at all the focus group meetings. No, it just was not discussed. Do you recall it being discussed?
No, it was not discussed.
Transitional use to hide where parking lots might look. The parking lots are unaesthetic. But transitional use, is that a planning and zoning term?
No, it's a common term. What it means is this, depending on the success of this operation, they may be able to raise capital to do other improvements to the property. So this could be a transitional use leading on to a different type of use.
Okay. Let me ask you about, because you talk about if they don't comply and sell these specific items, who's going to police that? I mean, is there somebody from the city that's going to go around checking every kiosk to see if it complies with this staff report, whatever?
I like to candidly say that Tarpon Springs has an interesting way of policing itself. The amount of, we have a code enforcement officer, obviously, but she is sometimes inundated with complaints, inquiries, phone calls from not only adjacent neighbors, but people just in their general area. So I'm pretty confident that if the right types of goods are not not sold in these kiosks, then a phone call will be made to code enforcement.
Okay, thank you. Any other questions for staff this time?
Chairman,
Yes, sir.
it's been brought to my attention that you own property in this area.
Mm-hmm.
I think you need to recuse yourself.
Because I own property?
Yeah, in the area, which could be, affected by this decision.
Geez, I mean, when was this brought up? I was here last time we discussed all this. What does that
It was
have
just
to
brought
do-
to my attention.
Well, what is that, that's common knowledge.
Well, not to me.
Well, Rodney knows about it. Everybody else here knows about it.
Well, all I can tell you, sir, is there are Florida statutes that talk about a conflict of interest having to do with whether the decision you're making may produce financial gain, and then there are a number of cases that try to define that. In the case of property, and fundamentally those cases hold that if you if you're considering a zoning matter or planning a zoning matter, and you own property close by that could be affected by the action, and some of your questions go to property values, that you probably have a conflict of interest which requires you to recuse yourself from the decision.
We're in a very small community.
Well,
I have a home here too.
I didn't make the statute. I'm just telling you what it says.
So your professional opinion is that I recuse myself.
Yes.
Okay.
Question,
I'll pass.
if I may, before.
Yes.
Is there a distance measurement with regards to adjoining property value, Mr. Yakubov?
No, it really isn't a distance measurement, and the cases are not that precise. And it's to some extent it's a catch-22 for a government official.
And the only reason I bring that up is because, as Mr. Franzese says, many of us know he has property down in the sponge docks, and if my memory recalls, I don't know Dr. Franzise's property holdings, but I believe he has a piece of property on alternate 19 that's near the Greek Pizza Kitchen, and then he has a house right around the corner from there on Athens that is near the Greek Pizza Kitchen. It's also near, I guess, I don't know what it's called now. It was original Pappas Strip Market, the Black Grouper, Captain Bill's, the one on alternate 19. He voted and spoke on all of those, so that's why I'm curious, is there a distance measurement with regards to recusing yourself? Because he has voted on other issues within this area that I guess, in a sense, if this not a distance thing, he could have been forced to recuse himself before. So I'd just like some sort of a clarification on that point. Thank you.
I will give you a memo on the requirements of Section 1112-3143 of Florida statutes regarding voting conflicts, and what the cases say about property. As I say, it's not a black and white decision. It kind of looks to the diluted effect of distance and things like that. But I would suggest, as an attorney, when in doubt, since it's a crime.
Mr. Yakubov, I have property in the CRA, so
well, that may or may not disqualify you.
I'm in the CRA. I have my old family home there. I have a vacant lot, and I have part interest in the store. So, in other words, you're saying that any issue regarding the sponge docks, if I'm on the planning and zoning board, anything in the sponge docks, I automatically recuse myself, or anything on North Pinellas Avenue, which is, one of the major arteries in Tarpon Springs, or even Athens Street, which is a historic street also, then I should recuse myself from everything?
I don't think I said that. It's a case-by-case decision depending upon where your property is in relation to the affected property, whether...
Well, I'm in the Springstocks. I can't help it. What am I supposed to do?
I don't know. All I can do is tell you what the statute says and tell you what the law is, sir. I'm not going to argue. I didn't draft
Mr.
the law.
Vincent,
In a case, and Mr. Yakson is probably more of an expert on this than me, but I seem to recall that if there's not a direct financial advantage or impact on the decision, the board member need not recuse himself or herself if he believes that he can render a fair hearing to all sides and render an unbiased decision. Is that not correct? Where you don't have a direct financial impact.
Let me find that statute. Give me a second. You are correct. Section 112.3143, voting conflicts. Section 3A, no municipal public officer shall vote in an official capacity upon any measure which would inure to his or her special gain or loss, which he or she knows would inure to the special private gain or loss of any principal by whom he or she is retained, to the parent organization or subsidiary of a corporate principal by which he or she is retained, other than blah, 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 or which he knows would inure to the special private gain or loss of a relative or business associate of a public officer. Such public officer shall, prior to the vote being taken, publicly state to the assembly the natures of the officer's interest in the matter, from which he or she, no, it says they shall not vote. He or she is abstaining from voting, and within 15 days after the vote occurs, disclose the nature of his or her interest as a public record in a memorandum filed with the person responsible for recording the minutes of the meeting, who shall incorporate the memorandum in a minute. So that's a positive statement that no municipal public officer shall vote upon any measure which shall inure to his or her special private gain or loss.
Private special gain, isn't that more like a direct impact on financial, on the member?
No, as I just explained, the case is it's more than just money in your pocket. It's broader than that.
So in other words, people who serve on boards have property in Tarpon Springs, and something that could be 3 blocks away, issue comes up, that means they have to recuse themselves if they're in the same neighborhood. And we had a zoning issue or a property had to be divided, and this comes up all the time.
Well,
I mean, I live within the city limits of Tarpon Springs, then I have to recuse myself. You're talking about the sponge docks. I mean, that's a big area.
Well,
how about North?
and the game
Wait a
thing,
minute.
right?
How about North Pinellas?
well,
And how about
again,
Athens
sir, I'm
Street?
not gonna debate with you. Okay, that's not my point. I'm pointing out the statute, and I'm pointing out the case law. I didn't write the cases, I didn't write the statutes. Where is your property in relation to the property under consideration?
I don't know, I think it's about 300-400 feet away.
I've read.
You're not allowed to talk. No one's called up.
Okay.
Okay.
I'm just, it's up to you whether you think you have a voting conflict or not.
Okay, this is gonna come up, probably with everybody on this board at one time or another. And then we wonder why we have trouble filling, city boards with people. Well, just for the sake of having this proceeding go ahead, I will recuse myself, pass the gavel to Vice Chairman, Mr. Delankis.
I believe at this point, is there any further questions from staff? Okay, I believe the applicant is up next. Is that correct?
The applicant gets across the gym and then
Okay.
the intervener can come up.
Say again, please?
The applicant and then the intervener can
All right.
cross examine staff.
Would the applicant care to, question staff?
Beverly Belair, 1028 Peninsula Avenue, Tarpon Springs. Good evening. Rodney, when we discussed the right-of-way, or the easement, I should say, to the city, did we not make it clear that we would, when we discussed it, that it would not be through perpetuity that we would be doing this?
That's correct. We had discussions and conversations about future plans for the property, and you were clear that you wanted the easement to be revocable, so it would not limit your future options for developing the property.
And the reasons I stated and put that in there was because, we were approached all the time to sell the property or lease the property to someone else to build a structure. And we would build, if there was a structure built, it would be built probably to the street, so it would be a walk-in like all the other stores down on the docks. It would be compatible. And I believe I did say if we could keep the existing trees, we would, but if a building went in there, we would have to remove them. And would we not be required to do some aesthetic other greenery on the property?
Yes, there would be public frontage landscaping that would be required as part of the site plan approval for the new building.
Okay, thank you. Does anybody else? They don't ask me now.
No further questions, ma'am. Thank you. Ms. Clemens, you may approach the podium and questions only of staff.
Good evening, Mr. Chapman.
Speak in the mic.
Can you hear me? Okay.
Can y'all hear her? Okay.
Right, Mr. Chapman, if we could start with the issue that was just raised, the issue of the revocable easement. Who would be paying for the landscaping?
The city would be paying for the trees out of the tree bank fund we have.
Normally with a site plan, isn't landscaping required anyway?
Yes. Mm-hmm.
So the city could require that the landscaping be put in that area anyway. An easement's not really necessary here. Isn't that correct?
That's correct.
So the issue of a easement is illusory. The city's really not benefiting at all. It's something that's not gonna be there.
I would disagree, Ms. Coburn. We had the public meetings for the Sponge Docks Improvement Project. A lot of the discussion centered around, again, providing pedestrian comfort and aesthetic improvements to these open parking lots. But at the same time, there was talk about still maintaining the existing sidewalk width. There is no additional right-of-way between the back of the curb and the property line to be able to provide landscaping and still maintain the existing sidewalk width. So the discussion centered around how do we keep the existing sidewalk width while having the opportunity to provide additional shade and landscaping. And the only mechanism by doing that is a landscaping easement.
Well, my question is, as part of the site plan, why can't the requirement be that the 10 feet of trees be along the edge of the new site plan for the development? Why do you need an easement? Yeah, why do you need an easement? It's a requirement of a new site plan, landscaping. Why can't you make that a condition of the why do you need an easement?
Because the SMART code is different than other parts of the city and the land development code. Normally, in other areas of the city, we have setbacks, and what those setbacks are minimums, meaning you have to have a minimum distance between the front property line and the front of the structure. That distance can be greater than the minimum, but it can't be lesser than. In the SMART code, the requirements are reversed. There are maximum setbacks, and if we were to require them to place a line of landscaping between the property line and these structures, there would not be enough room for the trees to grow in a healthy fashion without having that encroachment and having them be encroached upon by the kiosks. It's the same reason why the oak trees on the Sponge Docks across from the Sponge Exchange have not grown any larger than they have already. Those oak trees should be much larger than they are now, but they are not because they were not planted in a large enough space.
Well, also the salt water underneath probably keeps them.
Oak trees are salt tolerant.
It's still to the point, though, I don't really understand why landscaping, the whole point of the landscaping is to create a boundary to hide the parking lot, correct? To improve the
and
area?
provide shade, yes.
Okay. And that can be done with other trees than oak trees, correct?
The oak tree is the preferred tree for shade and other purposes here in Tarpon Springs. I've been involved in several landscaping projects and all the public meetings. That's been the number one tree that everyone wants. There are other trees. Primarily people choose them and they like them because of their large canopy. They're somewhat evergreen and they provide a nice look, a nice aesthetic to the area.
Well, this application has a site plan. What is the landscaping requirement other than the city-bought trees that the applicant is going to plant?
The applicant is proposing what you see on the conceptual site plan.
Okay. I don't see much.
Well, again, this is different in the SMART code than other codes that we have in place in the city. Before we adopted the SMART code, our landscape requirements were centered around parking lots. So the code reads that if you have your parking lot landscaping, there's a particular section of the code that deals with parking lot landscaping, that's where your landscaping would go. But in the SMART code, it's handled a little differently. The frontage, meaning the area between the sidewalk and the property, is where you would put your landscaping in the form of tree wells, open green areas, and the like, rain gardens and so on. So that's why this is the appropriate location for the trees in the form of a landscaping easement.
Well, the kiosk could be moved a little bit further back to accommodate the trees.
But again, then there will be violation of the setbacks because, as I explained to you earlier, they are maximum setbacks, and if you cannot push the kiosk back further because then they'd be in violation of the setbacks.
But the setbacks can be adjusted according to the non-conforming property, isn't that correct?
No. This would not be considered a non-conforming situation because they are putting in new improvements.
Okay. the other issue was if the city is in dire need of shade and space, there is eminent domain available if the city wanted to get an easement, correct?
Theoretically, yes. Practically, no.
It's an option that's out there that's not being used, correct?
Theoretically, it's an option. Practically, that is just not on the table.
Okay. Now, I provided everyone with a pamphlet. In it, it had the table from the SMART code. And if you notice, there's the line for kiosk, and there's also the line for open market. And it has all the different areas of the city, correct? That's what that means?
Yes. Mm-hmm.
Okay. Where the area that's highlighted for kiosk, there isn't a single area anywhere that's by right. Is that correct?
That's correct.
As far as the open market building, the reason to have an open market building is to have an open market. That's by right only in the sponge docks, correct?
That's correct.
Everywhere else it's a conditional use, correct?
Yes.
All right. Every single kiosk anywhere in the city of Tarpon Springs, each individual one requires a conditional use application, correct?
If it's within the CRA of the sponge docks, it would require conditional use.
And every other transect that lists the availability of kiosks, isn't that correct?
There are other areas outside of the CRA and the sponge decks that are not governed by the SMART code and would not require conditional use.
Right. I don't know these codes, T4A, T4B. What area of Tarpon Springs is that?
It's hard to describe it specifically. There's a map in the document that identifies where these areas are located.
Okay, so the Walmart parking lot, the Publix parking lot.
They're not within the CRA or the sponge docks.
Okay. If a conditional use is granted today for 6 kiosks, are you not setting a precedent for someone who has a parking lot that they claim is unattractive to pedestrian traffic to put 6 kiosks at Walmart parking lot, Publix parking lot, Winn-Dixie parking lot, the area where Muzzy's is?
I don't think you need to answer that question. I believe that's asking for an opinion. Your point at this point, Ms. Clemens, is to ask questions of staff, not their opinion.
I'm asking him if he knows.
I think he answered you that
No,
Walmart and those places are in different parts of the city, not under these regulations.
Well, I'm asking him not just about Walmart, but these other areas. So are those areas within the SMART code?
No, and secondly, I think as you're well aware, each application is evaluated on a case-by-case basis. There is no precedent setting. Each application stands on its own merits. So what is done for one applicant does not bind another applicant to the same rights or decisions.
Okay, but if you give a reason, such as to hide a parking lot, that reason becomes a precedent for the next conditional use applicant, does it not?
No. What we do is we evaluate the application versus the criteria. It's that straightforward.
That's fine. All right.
I think I need to point out something about a conditional use, which is very relevant to the discussion. You know, the SMART code has permitted uses and conditional use. The fact that a kiosk is a conditional use in that district means that the decision has been made that it's an allowable use in the district. The only question is whether certain conditions need to be attached to it in the interest of the public. Do you understand my distinction?
Thank you, Mr. Young.
So, you know, the code has already determined that kiosks can be there. It's just that's conditional as opposed to automatically permitted.
Okay. Now, the applicant on the agenda is listed as 6 kiosks / market. And there's a big difference between the two. And I think that we need to know whether this is a 6 kiosks or a market. So that needs to be established because it's 2 different things.
And I think I've said it probably half a dozen times now where the application is about 6 kiosks.
Okay, so it's not an open market and that should have been deleted, correct?
The board is evaluating 6 kiosks.
Okay, so the board did not evaluate open market, correct? That's not part of this
We're
discussion
evaluating
today.
6 kiosks.
I have not seen the application itself. Did the application request open market?
No, it did not.
Okay. Now then, I also provided you with a list of all the known kiosks in the city of Tarpon Springs. And because...
Okay, you're presenting evidence at this time. Do you again have a question of staff? You will have a chance for your 10 minutes to present evidence at that point.
Well, it's questions that I want him to answer about it.
With regards to what you're presenting,
That's correct.
you haven't presented that into evidence yet.
So will I have the opportunity to
Yes,
read?
you may
Okay.
at that time discuss it, or you can ask in cross-examination and rebuttal. But you're introducing evidence where you haven't had the opportunity yet for that introduction.
Okay. All right. Mr. Chapman, with regard to the Land Development Code, the definition of kiosk, we read into the record, correct?
Yes.
And you have that there. When you add more than one kiosk to a group, you're now creating a retail area, correct?
A retail area? I'm not really understanding the question. If you have a structure, a kiosk-style structure, and you're selling tickets or whatever you're selling out of it, that is a retail operation, whether you have 1 or whether you have 6 or whether you have 16.
Okay. The kiosks that are in existence in the city of Tarpon Springs are all located at the Sponge Docks, isn't that correct?
Can you say that again?
The kiosks that exist in the city of Tarpon Springs, with the exception of the one at Howard Park, are all at the Sponge Docks, isn't that correct?
I haven't gone out and inventoried all those type structures throughout the city. The ones that I'm familiar with in relation to this application are on the Sponge Docks, and we have pictures of some of those in the staff report.
Okay. The compatibility, point of order, Mr. Jalakis, as far as questioning him, I really can't question him until I present my evidence. So do you...
I would say at this point, your questioning is limited to staff reports, staff comments.
Okay.
Anything else you want to bring in, you can bring in at your time, ma'am.
Okay. Did you do, have you, I recall your testimony earlier regarding adjoining property values, but did you do any research regarding the adverse effect on adjoining properties when there's flea market type structures, like a fair type environment that's next to the adjoining property? Did you do any evaluation of that in your studies?
No.
So you have no, in your statement you said there would be a positive impact, but you don't really know whether a negative impact could result because you haven't studied that particular type of environment?
Well, I believe it's intuitive to believe that when you invest in property and you are expending a certain amount of financial resources, that expense will be evaluated when the property is appraised. I don't know how many appraisals you've looked at, but that is definitely one of the items that are used in the analysis of the property.
Well, the analysis says a positive impact or adversely affecting adjoining property values, but values aren't just a property appraiser's value. It's also whether or not the property is able to maintain a retail business, whether it's successful. are you saying that, the use of the property can't be negative and actually affect it adversely?
Yes, if they were to put in a cement factory next to, down in the sponge docks, then yes, that would have a negative impact on the property values of the surrounding area. What they are doing is not inconsistent with the current uses that are down on the sponge docks.
Okay, but, a flea market can have an adverse effect. As far as you know, you didn't study it, correct?
And the applicant's not asking for a flea market.
Thank you.
Okay. Now, in your comments, on page 5, number 6, I'm assuming that should be, removed based on your testimony where it says open air market? That's on page 5.
What that section of the staff report is the comments that were voiced on the application by the Technical Review Committee at the November 29th meeting.
So that references the 21 kiosks that were previously requested, correct?
That's correct.
And that's not for today's consideration?
That's correct.
Okay. In your comments on page 7, you state that you have a qualifier to paragraph 1. Only 6 open structures along the road frontage are requested for approval at this time. That suggests that there is a plan that might have been discussed for additional kiosks. Is that correct?
No, that's not correct. That qualifier, as you call it, was put in there to clearly demonstrate that this is, the 6 kiosks are the only proposal that is under consideration at this time.
Okay. In other words, you're asking for 6 kiosks, period.
There's nothing that the city has ever done that will prevent a property owner from coming back at a subsequent future date to ask for additional development rights on the property.
Okay. Okay, I will like to have Mr. Chapman available to question in my case in chief.
That will be provided. Thank you, Ms. Clemens. Now, at this time, I believe it's time for the applicant, if they would like to come and present their case, please.
Again, Beverly Valiers, 1028 Peninsula Avenue. Well, I think everybody should take a deep breath. It's been hectic and we haven't even started. First and foremost, this application is not a flea market. It's for 6 kiosk structures on the front part of the property. I want to thank the board for letting me come back, and the last time we were here, the plan was a much broader plan. We revised the plan mostly because the other one was over a long period of time. We listened to some of the comments from the board, and we took some of those into consideration and rethought the plan. And this is the reason we're back. Since the attorney has mentioned several times on the mic that this is a flea market, and it's being kept called a flea market, by right, in the SMART code, I can in fact have a flea market and not come before a board. That's not the intent of what we want. A flea market, open air flea market, would allow me to put up a single roof the length of my property. Somebody pulls up their car, empties their car, puts their items down on a table, and whatever they're going to do, they're going to sell their items out of the car, pack up, and every other day there's somebody else, and there's no guarantee what's going to be sold. There's no theme. There's no integrity to it. My husband has a long time, born and raised in Tarpon Springs. He's been involved in this community all his life. He has promoted tourism his entire life for this community at expense to him with no monetary value over the years. Over the films that he's made, it's all to promote the city. If you go down to the sponge docks and you look at an empty parking lot, as a former mayor, I will tell you, it's not eye-appealing at all. It's not attractive. It parks cars. That's all it does. What he's asking for, or what we are asking for, is we have looked at this property and said, this isn't good enough. We're also looking at the market where it's been. And in previous statements before, when we were here before with a larger plan, a lot of people made a lot of derogatory comments about George. And I sat there and I listened, and it's a man who's only worked for this city. What we want to do is, I've been down there 30 years, George has been there his life. I remember the sponge docks when it was shoulder to shoulder in the street. You couldn't walk for people. We don't have that anymore. And yes, we still have tourists, and we still have a flow of traffic, but nowhere near what it used to be. And for whatever reasons, whether it's weather or our climate or storms, the economy, it's changing. What we looked at this property and said, what could we do in the interim, because eventually we will develop the property with a structure. What can we do in the interim that can still attract and bring people down to the docks, to keep them there, something else to look at, bring some diversity. And the 21 kiosks, I guess, was a little too much to absorb the last time. It was too broad. So we said, okay, we'll take this in baby steps. Let's do 6 kiosks that they have different items to sell, different than what's down at the docks, consumable items, that people will come and walk around. There is a plan for the trees to go in, and I know we talked about oak trees, but I've also been talking about olive trees, but with benches around the olive trees. The scope of the plan, is, as I said, it's baby steps. Let's see if this works. Whether a structure, a building, a store down the street, they don't want any competition. The last time it was about competition, which is not relevant to the decision making. However, competition is what everything's built on. There was a time there was more than one sponge diving exhibition. What it meant? Everybody made money. Because everybody offers something different. If you bring something different, people walk in. You go down to the sponge docks when we do the Night of the Islands, it's packed. Who would have thought that opening it up and what we had to do to make that happen as a board, it's very successful. The merchants down at the sponge docks put up tents several times a year and block off the street. And those people come, they put up their tents, I believe there's a formula, the merchants get a percentage of something, I'm not sure. But the dollars, most of those dollars leave the city. They go away with outside vendors from somewhere else. Those don't stay here. What we're trying to do is bring in some vendors that will be in a lease agreement year-round, and they're there, they have a following. If we have a gentleman that's going to sell olives or international coffee and tea packaged, those people have their own following. Once they develop, people come. They not only walk through the parking lot, the front there, and stop to buy. They go into the restaurants. They eat. They look at the other shops. It's more people in the city of Tarpon Springs. What we're looking for is diversity versus no improvement to the property. Okay, that's an option. But as I said, there's been discussion that we're putting up tents. There is no tents. The structures that you see are the basis of the structures. We have a kiosk down there now. It's been down there at least a couple of years, Rodney, maybe 3. He's been very successful. He sells eucalyptus oil. It's not adverse to anyone down there. I don't believe any stores have closed because he exists. I don't believe that 6 kiosks will close any stores down at the Sponge Docks. It's not an adversity to bring diversity. I will say that I do want to make one other quick comment in my presentation. Mr. Franzese, I didn't know till tonight that you had a conflict, but I will tell you, as a commissioner and a mayor whose family has properties at Sponge Docks, there were many, many cases that I did not vote on, and I had to recuse. And you just are happy for the ones that you can vote on. But when you do own property, and I did not know you did until tonight, I honestly didn't know. Let me see what else I have here.
You have additional time. Go ahead.
I'm sorry?
You have additional time allotted to you. Go ahead.
Oh, good.
You're not anywhere near.
One other comment, as we listen the rest of the evening of some of the comments that will be made here tonight, George Balearis is a property owner, not a tenant at the Sponge Docks. He's not in a lease. He owns property. Many of the comments will be made from people that are tenants. They do not own, they own businesses, they have investments. And I'm not trying to belittle that in any way. But we are property owners at the Sponge Docks with huge investment. We would not do anything to our property to impair the value of the property or sale of the property, if that may be someday. But what we're trying to do is improve the property. It certainly is not a welcoming sight. It's not aesthetic today by any shape of the imagination. Not at all. I don't see how 6 kiosks can be detrimental to the Sponge Docks with the trees and some other aesthetics. We will meet all building codes that are required of those structures, and that we will have a discussion with staff and the certain agencies that we will go through to follow that. The other thing, let me see. There was a comment about this was to hide a parking lot.
Part of what?
The comment was made just previously that our intent is to put trees to hide the parking lot.
Okay.
We're not hiding the parking lot. We're improving the parking lot. We will have parking behind the structures. We will keep part of that parking since we're not developing the rest of it as our original plan. And in the future, if this is not, doesn't work for any reason, whether the city's not happy or we're not happy, the structures are breakaway structures, they'll be taken away, and something else will be done with the property. Okay. Compatibility. It has been said that this is not compatible. The structures that are kiosks down at the docks currently, some of them are not so eye-pleasing. Some are fairly okay. The structures that we're going to put there would be obviously better constructed and much more eye-appealing than what is already there. Since there are other structures, then it does fit in with the compatibility. If it's not compatible, then my request would be that every single one of them be removed, because then they would be in violation. Okay. Just catch my notes. Our code, the SMART code, and I was fortunate enough to serve this board when the SMART code was put in place. The intent of the SMART code was not to stifle diversity in our community and our business ideas. It is not a code that is supposed to be rigid when it's read. It is supposed to be broad so that we as a city can look at ideas differently than we've looked at them in the past. Try new ideas, and if they're successful, all the power to it. And if they're not, then we make the changes that need to be made to make other things work. And that's my biggest concern when we sit here and go, we can't have that because it's competition. We can't have that because it's different. It's not what we have. You know, it's not brick and mortar. We have more responsibility because it's a bigger building. Does that mean that if I own a smaller shop than the guy next door, I didn't have any right to be there? You know, it's all relative of how you look at it. But again, the SMART code was not written. Our old codes that we had, and some are still there, were very rigid. And many developers and ideas came before the board in the 12 years that I've served this city, and we were restricted so much about what we could allow because of what the code said. And we went to training, and we understood what the SMART code was about. It was allowed to make areas more pedestrian friendly, eye appealing. People, what is wrong with, and in the SMART code, with a kiosk, somebody walking up to a kiosk to purchase something different. It is all part of the SMART code. That was the general intent. At no time when it was put in into the SMART code that the idea of a kiosk was not such a permitted use. It's an idea. It was a thought that, gee, this is something that we could do. For several months, the Pappas property put up tents, kiosks on their property, flea market, every other weekend for a long time. They were trying it out. Nobody tried to shut them down. And that was private property, just like mine. So, do you have any questions or later? Or are you going to ask me questions now?
We'll ask a little bit later, ma'am.
Later?
This is your time to share
that's
with
enough. I think, we can ramble all night back and forth, and I choose not to.
Yes.
There's a lot of other items on this agenda this evening.
Well, we'll give them their time that you're also due now. We're worried about you right now.
Thank you. But
we'll worry about them later.
I certainly appreciate your consideration, and only ask that you keep an open mind to diversity and change in our community. Thank you.
Thank you, ma'am. At this time, the intervener has 10 minutes beginning now. You present your compelling evidence that you're above and beyond the other public.
Unless she wants to cross-examine.
She allows to cross-examine.
That was her case.
That was her. Is that, do we have, in our process, the intervener cross-examines?
Well, it should be Rodney, but I think he's the call of the line.
Well, my understanding is the applicant presents theirs, the intervener presents theirs. They can cross-examine at the end.
No. The applicant
Am I correct, or am I?
This is an evidence, and city staff and recognized interveners have an opportunity to cross-examine the applicant.
Okay, presumably the attorney subject question on board subject cross-examination.
Yes, Ms. Biller presented testimony, and so the intervener would have a chance to cross-examine.
Okay. Just a second. Stand by, ma'am. The applicant or his or her representative attorney subject questions from the board subject to cross-examination by the staff and any interveners. We'll allow you a short amount of time to question.
Okay, Ms. Blair,
Speaking to the mic, you're gonna have to share, I know.
the existing eucalyptus, do you have a lease with that gentleman?
Yes.
What, is it a written lease?
I don't think that's purview to this.
Yeah, she answered the question.
I'm sorry?
You answered the question, you have a lease.
Yes.
The rest is private information.
I don't
Right.
know.
Does he keep regular hours? Because I only see him open on the weekends.
That's not pertinent to this case.
Well, it is if you're gonna have 6 of them and they're never open except during the season, on Saturday and Sunday.
I think you can question her about her hours of operation if that's your intent,
That's
ma'am.
my intent.
Well, then ask that question.
What are your hours of operation gonna be?
The intent is they will be open during the day.
From when to when?
They'll be open from anywhere from 9 or 10 till the sun goes down, 5 o'clock.
Okay. Do you have any bricks and mortar structure anywhere near your lot? That has, yes.
No.
Do you have a bathroom facility, dumpster, any of those support facilities anywhere near your lot that are yours?
No, there's no need. When I go, yeah, that's part of when I go to another hearing. The time before to the dumpster.
What items are you going to be selling in your kiosk?
Retail.
What retail specifically?
I have applicants applying. I have someone wants to sell olives, somebody international coffee.
What else?
I would say that
I'm
if
still
retail covers a vast variety, I think by her stating retail, she's indicated it will be retail.
Okay, Ms. Blair, you have 3 kiosks on your property right now. Isn't that correct?
Yeah, I guess, yeah.
I'm going to show you 3 pictures. Are these a fair and accurate representation of your property?
Mm-hmm. Yeah.
So which pictures are you showing?
I'm showing the,
I only have 3 copies. They're in your packet, but they're very small. These are much larger. So
Okay.
it's
In which packet? Our staff report that staff
no,
provided, or
the
what?
intervener's packet. It will be admitted into evidence during my case.
Okay, so just clarification, Ms. Quinnes, we're talking about
16 pictures.
It would be the Blair's property? That's correct.
Does everybody on the board have a copy of the affirmative?
It's
Do you
on-
have a copy, ma'am? Okay.
It's on page 2. It's item number 5. Those are the 3 pictures that I'm showing the applicant. Only I have larger ones.
That's fine.
That's my property.
Okay, so
And I'm assuming the clerk has a copy of this?
Yes, she did verify that.
okay. This picture shows a tent with sponges underneath. Is that correct?
Yes.
And that's a temporary structure that you put out every day?
I believe, not every, no, yeah, mostly, yes.
Okay. Is this also your structure, this,
Ticket booth?
ticket booth? Yes.
Yes.
Okay. And the eucalyptus is also your structure?
Yes.
Okay. You have 3 structures there now that through whatever process the city has, it's grandfathered in. Why haven't you put 3 kiosks out there, gazebos? Why haven't you taken these away and done this already? You have the right to do it. Why do you need 6? If you're just trying to see how it works,
I
why
think
haven't
that's
you done it?
irrelevant at this time, ma'am.
Well, I think it is relevant.
Asking why she hasn't done something before, there may have been other issues that are irrelevant
Well,
to this
but now
process.
she has the ability to do 3 without even being here. So she's really seeking 3 more, correct? No?
Okay, let me clarify. The structures she's referring to, those will be replaced, other than the eucalyptus is already there, and the ticket booth and the tent will be one of the 6. We want to put something a lot nicer to look at than what you see in these pictures. That is the whole intent of the application. And to do that process and to bring that forward, I had to come before the P&Z. So there's 6 going across the front of the property. not 8 or 9, 6.
This building in the back is gonna remain
Yes,
just as it is?
that's not relevant.
Well, you're talking about beautification, and that's...
I'm talking about the beautification of the front of the property. My other application addressed that. This is just for the 6 kiosks, and that's all I am addressing, is the 6 in the front of the property. Anything in behind that is not purview to this application.
I don't have any other questions of Ms. Blair.
Thank you.
Thank you.
I'm ready to present my case.
Actually, we're going to take a recess. I see on the clock up there, it's 13 minutes to 9. We will reconvene at 5 to 9, and I will also ask the board members, as they exit and go to the restrooms, to please refrain from speaking to the audience. Allow the audience to put their comments on record. Thank you.
Speaking only about the case, correct?
Correct.
Well,
Well, yes, obviously about this case. Thank you.
I didn't show up.
We'll reconvene. The intervener now has 10 minutes. Your whole case.
Okay, if you will review the packets that I provided you, what they contain are a list of the existing kiosk-type structures that are on the sponge docks at this time. I also did an analysis for you with a list. I covered the grounds. There's 16 in the city. There's 15 on Dodecanese Boulevard. The way it breaks down is there's 1 kiosk per property up and down Dodecanese, except for the Sponge Exchange, which has 2. Now I'm assuming everybody's familiar with the Sponge Exchange. That's an enclosed mall with public bathroom facilities and dumpster and all the infrastructure. Kitzo's Yanni's has 2 kiosks, and they have a restaurant, and they have a complete retail business with multiple bathroom facilities. The only property that has the most kiosks is the Blears property. That's the applicant. They have 3. They have absolutely no infrastructure at all anywhere. The list is, there's 2 Georges, and if you'll look at your pictures now, you'll see you have on page 1, that's the west side of the sponge docks. You have the Giorgio property, and at this time I am moving them all into evidence. You have the Giorgio property ticket booth. They sell tickets, incidentals. It's an auxiliary part of the main business, which you can see in the back. It's retail, and also they have deep sea fishing, and there's bathroom facilities, and there's an area for the people that are going to go on the boat. That's the first one. So that ticket booth is an auxiliary building, and it's completely supported by the main building as far as facilities go. The second property is the Sunrise Cruise ticket booth. That's on the Levendis property. That's moving further down now on the sponge docks. Mr. Levendis has a large retail establishment with restrooms and dumpster and facilities, and that's his tenant, the Sun Lime Cruise ticket booth, and he has made that available to that person. Then you have the Christopoulos property, number 3. That's the St. Nicholas boat line. That has no infrastructure supporting it. That is right there on the sponge docks. It's been there for many years. Then you have page 2, number 4. That's the property. It's a parking lot adjoining the applicant. It's right next to Dimitri's on the Water restaurant. And there's 1 ticket booth there for the Spongerama River Cruise Line, which the Kitsos run. Then you get to the applicant, number 5. Those 3 photographs are what you see on this property. You see we have a ticket booth, you have a eucalyptus sales kiosk, and then you have this pop-up tent that sells sponges. This is an example of what has been there for 50 years. It's a parking lot with no beautification efforts whatsoever. And it's been continuously owned by the Belarus's during that time. Number 6 is Yanni's Restaurant and Kitsos. It's the Kitsos property. It's Yanni's Restaurant in the front, and they have the Spongerama in the back. There's 2 kiosks there. One is a ticket booth, incidentals, and the other is Nick Bada Bing, Tobacco King. Both of those are supported by the physical bricks and mortar structures that have restrooms and have dumpsters and facilities. Then you have number 7, you have the Low property. This is Riverside Venue. This is a Tiki Hut, and it's on the parking lot, and the person there is supported by the main structure of the Riverside Pappas Restaurant, the former Pappas Restaurant. Number 8, you have the Chalikas property. This is right next to their strip center. Yama's is in there. They have Cafe Greco. There's a series of tenants in there. This parking lot is next to them. The owners own Yama's, and they also own Paul's. So both of those bricks and mortar structures support this auxiliary building that's on this parking lot. It's also mostly self-serve, so there is no attendant, and there isn't much need there. Number 9 is the large Belarus parking lot next to Mykonos. There's a kiosk there. There is no bricks and mortar structure that supports that kiosk in terms of restroom, dumpster, electric, etc. Then on page 4, you have number 10. This is the Sponge Exchange, the Pappas family property. This is an enclosed mall with shops everywhere that are indoor and outdoor. There's air-conditioned retail, and there's also some outdoor shopping. It's from the street. It's enclosed. It's hidden. So when they do have various fairs there, it's not something that's out on the street that's going to be unsightly on the Decanese. It's within their property. You'll see that it has the snow cups, and there's a glass bottle art kiosk there. Then the last one is the Hulis family property. This is Mama Pappas gift shop. It's their parking lot right next door. They also sell parking tickets out of there, and they also have the deep sea fishing for Gulf Star. So they sell tickets. So this is also supported by the bricks and mortar structure next to it. So this is the extent of what is comparable to the applicant. And if you notice, everyone except the Belarus properties are self-sustaining and self-supporting. They provide their own bathrooms, dumpsters, electricity, etc. So the only properties that rely on the city facilities will be the applicant. They're the only ones that do now, and obviously they'll enlarge their use to 6 if you grant this. In the SMART code, it's on page 50, which is one of the documents I provided you. It's the Transex, I guess, table 4F. It talks about kiosks, and Mr. Yakubon made a point, which I think is one that all of you need to pay close attention to. Of all the uses that are listed on this sheet, the only one that has absolutely, other than the push cart, that never has a by right use is the kiosk. And the reason for that is the persons who came up with the SMART code were very concerned about kiosks, because there's the possibility that if you get too many of them, you create a very littered urban environment, some blight. And you also are now crossing over to where you're creating a mall, but it's kiosks. And so the fact that it's every single time somebody wants a kiosk, it's a conditional use is very important to note. In this case, we have the definition, and if you review all the other kiosks that exist on the sponge docks, they all meet the definition of kiosk. And as a matter of course, and I think that's also very important, it's what the city has allowed, essentially. It's pretty much allowed 1 kiosk per property. And each of those kiosks are auxiliary to the main building and the purpose. So there's not been this 3, 4, and 5 kiosks per property. It just doesn't exist. So you can't compare this application and say it's comparable with what exists, because it doesn't exist at the Sponge Docks. The majority of the property owners, with the exception of the Sponge Exchange, which is a mall and has all the facilities, have only one kiosk per property, and they support it. So this use does not meet the criterion. And the second point that I want to make I provided you with the Sponge Docks CRA Infill Code 1.3. In order for you to grant a conditional use.
Time out. Everybody in the board find where she's referencing? It's in the, says intent 1.3.
Thank you.
In order to find a conditional use.
Stand by.
I'm sorry.
Everybody have it? Do you have one, Bill?
It's a 3-page.
Okay, we're all good to go. Go.
Okay. It can only be approved. You can only approve this conditional use if it's consistent with the intent of 1.3. And 1.3 talks about the community, and every one of those points, if you read through, this project doesn't add anything to those 3 points. Retail is already there. There is no new, different thing that's going to come from this. The SMART code intended more mixed use or a different use, a recreational use, a living space, something different than what is already there in order to grant a conditional use, and it's not there according to this requirement. The standards for conditional use are clear, Section 209, conformance with the requirements of the code. The code requires the kiosks to sell incidental properties, incidental items like candies, and Rodney read that to you, so you understand that.
What are you referring to now that you seem to have jumped?
Okay, the next item is the standards for your
review. So you've gone to the next sheet.
Right, I apologize.
Thank you.
209. Number B, specifically, the use to which the property may be put is appropriate to the property in question and is compatible with existing and planned uses in the area. It's not compatible with the existing planned uses of kiosks. It definitely isn't. It doesn't. It's greater in number. It's non-supported, and it's its own business. It's essentially a market, and that's not what was intended. The SMART code planners put a provision for an open air market, and it requires a permanent structure. So you're essentially creating an open air market without the requirement by allowing 6 kiosks to group together. The other problem, of course, that we face is if you allow 6 on this property, anywhere where the SMART code applies, you're going to have applicants all over wanting 6. And you're going to have to justify why they got 6 and somebody else couldn't get 6. So as far as compatibility, it does not meet the compatibility requirement of Section B. It's not consistent with the goals and objectives of the comprehensive plan. Essentially, it's going to devalue the economic base at the Sponge Docks. If you start to create this multiple kiosk, essentially, I'm going to call it flea market or fair environment. It's like when they close the street and create the fair, essentially that's going to be the permanent type that we're going to have down there. And that is not consistent with what we're trying to do. We're trying to elevate the retail to a better customer, to enhance what exists down there, keep the businesses that are existing in a solid economic footing, and not degrade the economic environment.
You have 1 minute remaining, ma'am, to close up your presentation.
Well, now I need to bring my witnesses. I have several people that would like to speak. And in fairness, the applicant was given a considerable amount of time.
I've allowed you more time also. You started at 8:56. It's now 9:10. You've had 14 minutes, and part of your time earlier was commentary versus staff request. You have a minute left, ma'am.
The main point here is that, to do this is to open the door for urban blight on the sponge docks and in other parts of the city, because you're going to create something that we can't control. The city on its own has limited these structures to approximately one per property. They're supported. The city bathroom closes at 5 o'clock. The Pappas Sponge Exchange closes at 6 o'clock. The other city bathroom is the only available bathroom. It closes at 9 o'clock. So as far as being able to provide for their customers and their employees, they don't support it.
Time is up, ma'am.
One more comment, if I could, on the safety issue. These are blow-away structures. That's another reason they don't have to meet a lot of requirements under FEMA. According to Mr. DePasqua, this is considered a blow-away structure. So that's another reason why there's only one or two. If you had too many of them, you're now creating a safety concern for the public.
Mr. Chairman, I move that Ms. Coburn be allowed to present her witnesses, and the same courtesy be allowed to the other parties if they wish to.
She will be allowed her witnesses. I'm just saying her presentation time is up. So if you have witnesses, they will get 4 minutes.
Okay. Do you want them now?
Yeah.
Okay.
You're going to present them. Come on up. You got 4 minutes.
First of all, I need Tommy. Is he here for the Sponge Exchange? If you'll come forward. Mr. Kalouris is here to represent the Pappas family. He has a shareholder's interest in the Sponge Exchange and would like to present a couple issues.
These aren't the group you're representing, are they?
He's a witness.
Are these the group?
No.
Okay.
You said earlier you're not representing the Pappases then?
No.
Okay.
Sponge Exchange? This is someone from the Sponge Exchange.
In the Pappas Plaza, what time does the public access?
Okay, it's his time for 4 minutes to speak. It's not a cross-examination interrogation. He can tell us what he wants to say as his evidence.
Interveners can they call witnesses, Mr. Iacovone, and ask questions of their witnesses?
Yes, I think they're entitled to call witnesses with the understanding that their witnesses can't get up and speak during the public comment portion.
Afterwards.
Yeah. So she can ask questions to bring out whatever testimony she wants from them, but these people forfeited their right to speak at the public comment.
Okay, because my impression is that this was one of her clients and he wanted to comment.
Well,
so you're not a client of Ms. Clemens?
No.
No, sir.
Your name, your address?
My name is Tommy Kalouris. My address is 492 Denise Street, Harvard, Florida. Like Mrs. Coburn said, I'm here to speak on behalf of my family and our business. Some of the concerns that we have are obviously the maintenance of the property. Looking back in the past at what it looks like now and the way it's taken care of, we're concerned as far as what it's going to be taken care of like in the future. It's not a great track record looking back. Our concerns are also, bathrooms and dumpsters. I could go on and on, but those are some of our main concerns.
Does the Pappas family provide public use facilities in the Sponge Exchange?
Yes, ma'am.
And what are
Speak into the mic so it can be on the record.
What are the hours that the bathrooms are kept open?
The bathrooms are opened extremely early in the morning. I have a key to those bathrooms. I also am a business owner in the mall. I close those bathrooms according to my business, but normally the bathrooms are shut down at 6 o'clock, 7 o'clock at night.
Do you feel this type of business will affect the economic growth of the area?
Yes, ma'am.
In what way?
I feel that there's business owners all up and down the Sponge Docks and I don't think the Blears family, in my opinion, is going to regulate who, their tenants are based on what they're selling. If somebody's going to want to rent their spot out, they're going to rent it out. There's a lot of people in Sponge Docks that all sell the same stuff, and I don't think we need more of the same stuff in the Sponge Docks.
Thank you, Tony. At this point,
Yes. She gets to cross-examine. Okay. I guess the city does too.
You mentioned economic growth and damages. What is your field, sir?
I didn't mention economic growth and damages.
Oh,
Sorry, we didn't hear your answer into the mic, sir.
I didn't mention economic growth and damages. That never came out of my mouth.
oh, I copied them. Okay. You said in your opinion of the Blears' track record, is that an opinion, or do you have stats to prove, evidence to prove that?
That's a personal opinion.
Then it's not relevant to this case. Thank you.
I have one question.
in rebuttal, Tommy, do you recognize this?
No.
Oh, I'm sorry.
Go ahead, Mr. Chapman.
There was a question concerning the bathrooms and the sponge exchange. Mr. Coors, isn't it true that the city pays the Pappas family to keep the bathrooms open to the public?
Yes, sir.
Okay.
Yeah, that wouldn't come out anyway, but thank you.
Regarding maintenance of the property, do you recognize this?
Yes, ma'am.
What is it? A picture of?
It's a pop-up tent in the front of the Blears parking lot.
And what is it, day or night?
That is a nighttime photo.
Okay. I'd like to put this in evidence. It reflects the maintenance that's currently going on the property, the Blears property, the type of maintenance you can expect down the road. At this time, I would call Andy Salaveras to Andy.
Don't leave, Mr. Coors. Thank you.
My name is Andreas Salaveras, 628 Dr. Kennedy Boulevard. I own Mykonos, and I own the Dimitris with my son.
Mr. Salaveras, do you have bathroom facilities in your restaurant?
Correct.
If people don't have provide bathrooms, do you have to provide bathrooms to people who aren't restaurant patrons?
Most of the time.
So, are you concerned that if they fail to have structure support for their business, that you may be providing bathrooms?
They have to provide bathrooms. No business without bathrooms.
But in the event that they are granted this and don't have bathrooms, is it your concern that your bathrooms are going to be used by people that need restroom facilities?
Of course.
Do you feel that this is going to impact in a negative way your business?
I want to say two things. Number one, I want to respect Mr. Blears. I have the friendship with them many years, and Mrs. Blears. We agree with so many times. We used to be on the board of directors on Association of Sponge Docks. This time, I don't disagree with him and with her for two reasons. Number one, so many years, what do they do for these parking lots? Number two, we want a flea market. I wanted, and I asked the board to remove from this application the words outdoor market. It means flea market. The city, they say beautification, so many signs on the Sponge Docks, and we wanted to beautify the Sponge Docks. We wanted to upscale the Sponge Docks. And I say many times and many years when Mrs. Bleary used to be mayor, and Mr. Bleary, let's do something for the Sponge Docks to create more upscale. What we do now, we have applications for them to decrease the beautification, and the business. And I asked Mr. Romney, I think, Mr. Romney, you mentioned you needed 3 years for Mr. Biliris to finish this building, so wherever you call it. Why you say so many years? Number one. Number two, I'm asking you, for your experience, you see another city in this area, Danita, Palm Harbor, Safety Harbor. I'm not going to mention the big cities, but the small cities, to have free markets every day? I don't think so. As you travel, I won't embarrass you, but I want to ask you, how much you know about the business? I don't ask any more questions for you, but I want to tell the board, this time is the time to create business in a spot that's upscale, not flea market. Thank you.
At this time, I would call Athena Sardulius with Tarpon Sponge Company. Just so everybody is aware, she is my sister, but she also owns a shop in the sponge. So I'm not going to question her. I'm going to let her just tell her opinion, which I think she's entitled to.
Hi, everyone. Athena Clements Sardulius, 634 East Orange Street, Tarpon Springs, Florida. I own, along with other shareholders, Tarpon Sponge Incorporated. We've been in the sponge exchange for 30 years. I have great respect for Mr. Biliris and his wife. On many, as Mr. Salavera said, on many issues we have agreed many, many times. But this project scares me, to be honest. I'm not going to go into long detail, but I feel that if this project were to go through, it would directly, negatively impact my business. Kiosks have a financial advantage over someone like me that's in a brick and mortar structure. All my costs are higher. Don't have to go into those. I'm sure you all realize that. This general flea market, open air market type of atmosphere infers a discounted level of pricing just by virtue of it not being in a permanent structure. So in order to compete, I would have to lower my prices and reduce my profit margin, placing a greater burden on my ability to meet operating expenses. Secondly, my customers use the public restrooms in the sponge exchange, and this project would place a greater burden on the limited facilities that we currently have. I'm also concerned about the precedent that this would set for other property owners. They would be within their rights to petition you for the same sort of thing. So I don't think open air market, flea market by the sea is a positive image for the city, and I fear the eventual loss of my ability to remain in business in my present location. That's all I had to say.
Thank you.
Thank you for your time.
That concludes my witness testimony.
Thank you. Okay, interveners. Okay, at this point, we'll now go to members of the public in support of the application. Members in support of the application. Okay, seeing none, presentations will be made by members of the public in opposition to the application. If you care to speak, more than one of you, please come down so we can get your comments and move from there.
I get nervous when I speak, so I'm not going to scream this time at anyone.
Pull the mic up a little bit to you so we can hear you.
Okay. My name, do I have to say my name?
Yes.
Okay, my name is Katie Karastinos. I am the owner of Sponge Diver Supply. It's a business located on Dodecanese Boulevard, 693. I'm here to speak in my opposition about the proposed six-kiosk market, flea market, whatever we want to call it. It is what it is. I think that it will be detrimental to the economy, the retail economy of Sponge Stop. I have concerns about how it will be maintained, as I have to deal with things like this on a day-to-day basis. This is a business that is operated, St. Nicholas Boat Lines. There are other partners in this business, but this is a business that George Balearis does operate. This is what the kiosk looks like today, this morning. I printed this photo out. I don't know if you want to pass it down or if everyone can see it. I have concerns about the kiosk, seeing that it's a big issue with signage on retail locations. We're limited to the amount of signage we're allowed to have. One out-facing sign, is this correct? I don't know if I need to ask the correct codes, and one sandwich board sign. The kiosks seem to have an unlimited amount of signs. Is this something that's correct? Because the eucalyptus booth seems to have signs completely around the entire structure. So I feel like this is going to be a flea market with limitless amount of signs and advertisements. I know that it's a 10 by 10 structure is being proposed for each kiosk, but how will things be displayed in each kiosk? Is there some sort of limitation to the clutter? Is there going to be center blocks used as display tables? So this is my next set of evidence. I could go on and on, but basically my husband and I both are in opposition, as well as many members of the city, which they're not here today, but we have a petition going that can be presented at the commission meeting if this gets passed through. So thank you for letting me speak. Have a nice evening.
Anybody else to speak in opposition? Is there anybody else? Okay. At this point, we will allow the board to ask questions of any of the interveners.
Well, I think the applicant, city staff, and recognized interveners have an opportunity to present rebuttal evidence, which...
Say again, we're at...
the applicant, city staff, and recognized interveners have an opportunity to present rebuttal evidence, which is not a rehash of the old evidence, but is only new evidence to address matters that came up after their case, and make a brief closing argument or summary. Applicant first, city staff, and then interveners. And I emphasize brief.
George is coming. It may not be all that brief. Again, Beverly Balearis, 1028 Peninsula Avenue. There was some comments against the reputation of the Balearis family and their business findings. The Balearis family has had high integrity in this community. The family's been here for 102 years. Whatever, close. But the boat line that it was brought up in question is on the National Historic Register. It is the main attraction for many years in the city, and at one time it was the first attraction in the state of Florida. My husband nor I, if we're going to talk about reputations here, my husband nor I have never been arrested. We've never been accused of drug trafficking or selling cocaine, of any of those types of items. And some of those who oppose this that have businesses at the sponge docks, quite frankly, some even being investigated today, cannot say that. As far as clutter, hanging all over in reference to that, I believe that there is a code that we need to follow, and we will follow the code recommended by city staff and when we go forward with the application. As far as clutter, don't throw stones, mostly because if you go down to the sponge docks, there's shoes hanging all over, there's T-shirts hanging from the canopies, they're all over. There's times that you cannot walk for the signs blocking people. Code has been called about it. They can't go down every day. I know I got calls when I was in office. So careful, because if it's really enforced, nobody's going to be allowed to put anything out. And that's not good. That's not the atmosphere you want. It's not about what he has and what she doesn't have. It shouldn't be that kind of battle, but unfortunately it is. In reference to the present kiosks that are down there, and I really don't even call them kiosks, they're structures in a tent. Quite frankly, that's what we're trying to remove. I don't get that, but if you're going to keep beating me up that it's there, I've acknowledged it's there. I've acknowledged that it is not eye-appealing. I acknowledge that the property does need to be improved. That's what we're trying to do. There is a kiosk of one of the clients that was represented here today that was built without a permit, and I believe they did get a forgiveness one, but at least we are Oh, I don't know. I'm not going to argue whether they have it or not, but I know they didn't. At the time it was constructed, we are at least coming before you, and we've gone before city staff, sat down with staff and said, okay, we have an idea. How can we do this? Let's follow the code. We want to definitely bring something positive to Tarpon. We're not here to make anything polite. And again, I want to repeat, this is not a flea market. It's 6 kiosks. I can put a flea market, as I said earlier. The code allows me to put a flea market with a whole lot of issues for being able to do this. I don't have to come before a board. I go before the TRC. I just put one structure roof up. The guy pulls up, dumps his junk out. I don't want that. Having them along the front, as we do, that we're proposing, will allow cars to go behind them, so you're not, when you're walking down the street, you're not seeing bumper to cars. You're not seeing windshields. You'll see retail. As far as the bathrooms are concerned of the existing properties, which I don't believe are purview to this, I don't believe anywhere in the code that says if you park a car you have to provide a bathroom. Okay? I don't believe it. I'll stand corrected by Rodney, but I don't believe if you have a parking lot you have to provide bathrooms. If at any point that it's required to have bathrooms put on the property, we will follow the code and put bathrooms. At this time, for 6 kiosks, I don't believe that is a detriment to the city for 6 people to stand in a kiosk and sell their items. I believe the city spent $150,000 for public bathrooms. I don't believe they'll overflow the public bathrooms with 6 kiosks. Does it mean that our 6 kiosks is going to bring 15 or 20,000 additional people to Tarpon Springs? No, it will not. I would love it, but it won't. I don't believe the traffic is traffic that's probably going to be existing there. Hopefully they'll come back. Yes, they may go to Andy's restaurant and eat and use his bathroom. I hope they do. That's the part of bringing people. I don't think there was a survey done here by anyone this evening to take account of how many people park on my parking lot and actually go in to use a bathroom. I don't know. I don't get the equation to that at all. I know George wants to speak for just a moment, and I'm going to make one final statement because he won't say this on his behalf, and I did touch on it. No, be quiet. As I said, he spent his life doing this, promoting this community. And those who have been here for 20 years and 30 years and 10 years and 3 years, quite frankly, and I will say this about George Billiris, he set the table for you to have the business. St. Nicholas Boat Line is a family business. As I said, it's been here for over 100-some plus years. They brought the tourists here before all the restaurants were built. Yes, they now come for restaurants, but prior to that, the people didn't know it was here. The 32 documentaries that this man has done, an unknown amount of magazine articles throughout the world and films around the world promoting this community. He is not about to build something that will degrade the community in any way. But he set the table for the people today that are up here complaining and trying to degrade him. And I'm sorry. I didn't say it last time, but I am going to take it at this time. George has served on the CVB board, promoting Tarpon Springs throughout the county, promoting our city so that we get notice and grants for our community, for the development for tourism. So when you talk about, no, it is necessary. So when you talk about his business degrading the community, then talk about how he has promoted this community. He brought back the sponge industry. He came back, rejuvenated the entire business, got people interested, brought Greek divers here. That's why you have businesses in your store. That's why people still come to Tarpon Springs. It's a historical community that he supported, and he still supports this. You know, the application, one way or the other, I've sat on that board. You do what you need to do. We can do an open air market without the board. I don't want to do that, but we'll do that if we have to. But don't stand here and degrade a man that has done nothing but promote this community all his life. And for those who do that and make comments in the audience and sneer, shame on you. Yes, I'm sorry, shame on you. Because this is a man that represented this city for 60 years. Thank you.
Long meeting, sorry. George Billiris, 1028 Peninsula Avenue. I'm a little bit embarrassed because of all the good things that I've done according to my wife. Let me say this. Whether you like it or not, all of you, none of y'all had anything to do at all with promoting or making a tourist attraction in Tarpon Springs. Not at all. You saw the traffic flow, especially you, Dave. You saw the traffic flow, so you run into Tarpon Springs and you made your money, and you don't even live here. What we're trying to do, at 85 or 86 years old, who the hell is interested in doing anything? I need this like a hole in the head, and I need this clamor and this talking. I'm so upset I can't even talk, and that's difficult for me not to talk. But the fact remains, you are in trouble. From 1 million people a year, from 1946 until 1999, you're down to about 450,000, if that. And you're going downhill every day. People that own businesses, own buildings, had better take this into consideration, because you're going to be like Silver Springs, Wickiwashi Springs, Cypress Gardens, a thing of the past. You're the most fortunate city in the entire world. Your Mickey Mouse is the Greek and the sponge. Your backdrop and your decoration, or whatever you want to call it, are your commercial fishing boats, your shrimp boats. Your commercial fisheries are what made you famous. They made you famous simply because media fell in love with the Tarpon Springs story. 5 full-length movies were filmed. More than 32 documentaries. I did 47 documentaries in 7 different languages. This one here, Greece, China, Australia, promoting Tarpon Springs with sister cities and everything else, in New Zealand. How many of y'all have done anything? All you do is take, give a little. Instead of having a meeting here trying to stop something, which we truly don't have any interest in doing it. And we thought that we would do it because there is a need. And I'll tell you what the need is, or what prompted all of this. 2 years ago, I went to Rodney and Planning and Zoning, or whoever it was there, and I said, I'd like to do something with the property. And then I went back home and I said, we're not going to invest a dime because tourist business is going down. What prompted this little flea market, as you call it, is a flea market that you have every time you have an event, with people from outside of the community taking your money and going home with it. That's your flea market. But it's a good thing, because it brings people. You should be smart enough to see, okay, tourism is down. Every time we put up an event, it brings thousands of people. It's great. Maybe we should do more instead of say, let's don't do nothing. Because that's what you're doing. Let's die a little bit quicker. You're young. I'm old. I'm done. If you want a future here in Tarpon Springs with tourism, you better wake up. And you better start thinking in the terms of doing things, not stopping things. And that's enough. I had enough of y'all.
I'm assuming this is your closing and rebuttal.
Yes. Oh, I'm sorry. Rodney, I'm so sorry. Would you like to get up here?
Just, and I'll be brief, I have 4 points.
Well, actually, to be honest with you, this is kind of new. I mean, I've been through them enough, but when Mr. Iacovo had mentioned, it's time for summary rebuttal, actually, we had never gone through board cross-examination. So, I don't think that, since we've kind of not done board questions, that's why I say I will allow you to go next, because technically, the applicant goes last. So you can give your summary rebuttal, and if staff would like to have some summary rebuttal, then we will go to board questions. And then when all the board questions are done, we'll then go to motion. So are we clear? Okay.
Okay, just to begin, and this is very quick, Mr. Beliers did not set my table. My table was set by my grandfather, Emmanuel Clemens. He came here in 1905. He was a sponger, and he set Mr. Beliers' table. So we all have family that have been here a long time, and that's not the point tonight. The point is that nothing's happened on that property for 50 years. So that's a fact. Now, this property, this plan is not the right plan for that property. That's one of the finest properties. It's on the water. This is not the best use of this property. Putting kiosks to block the water on the right side is a terrible, terrible mistake. People drive down the Decany so they can look out. You're going to hide the Gulf side by putting these kiosks on the street there. That's not an enhancement, and that's not what people need to see. From the standards of review, this thing has not met the standards. It doesn't conform with the code. It's essentially a way around to get a market, and it's not a market. Kiosks, by what we have, are limited for a reason. There's only one per property. That's what we should allow. Somehow they've gotten 3. They have their 3. They want to have their 3. Let them do their 3. They have 3 now. I agree it would be a definite improvement from what they have. But to put 6 and more, you're now moving towards the market. And at that point, you've got to have infrastructure. And that was why the city made the recommendation when they got to the 21, because the bathrooms are needed. It's a common sense thing. The code doesn't require it, but you have the right to put a condition on an approval, and infrastructure has to be part of your thinking when you have this many now. You're starting to create a market, and you need to accommodate the people. And frankly, Mrs. Beliers, employees at parking lots use the bathroom, and they need to go to the bathroom. So that's not a ridiculous comment. If you had 6 employees in kiosks, they have to go to the bathroom. Their patrons have to go to the bathroom. This is a common sense approach to this business. This type of low economic retail is going to diminish, not enhance the sponge docks and the existing properties. It has the potential to blight our sponge docks and any other area in the SMART code if you start to allow more than what we have determined to be fair, which is about 1 per, even though you have a couple that are a little bit more. It's not fair to make them an exception to the rule that applies to everybody else, and that's what they're asking for. So I'm asking you to deny the request, that it does not conform with the standards A, B. It's not consistent with the current use. It's not consistent with the comprehensive plan. It will adversely affect adjoining property values. It's not supported adequately by infrastructure, and it's not, the impact on growth patterns for the city is definitely negative, because if you start to get a whole bunch of these types of little gatherings of kiosks, you're now creating a whole nother picture for Tarpon Springs. And this is not the way we want to go. Thank you.
Okay, Rodney, would you like to give a summary or rebuttal?
Yeah, just 4 quick points. There was a question about if this is approved, how many signs, would they be allowed? Section 189.03, paragraph D of the code allows for 1 wall sign per establishment. 2, as the applicant stated, they did have a conversation with staff after the last hearing where other options were presented to them. As Mrs. Beliers stated, a flea market or an open market building is a permitted use in this district. There was discussion about what that would look like, and it would have posts and a roof structure and no walls. And she clearly indicated, and it would be 500 square feet or less, which wouldn't require a public hearing site plan. And she clearly stated at that time that that was not her intention, and she did not want to go forward with that proposal. 3, water and sewer capacity. Everybody's reading into that one particular criteria, and it has always been evaluated on the capacity at the city's wastewater treatment plant. Secondly, the city knew that there was a need for public restrooms down there. That's why we paid the Pappas family to keep the sponge exchange open for public restrooms. That's why the city spent $150,000 or $60,000 to build the 4 new bathrooms on Hope Street. That's why we did the same thing, spent over $450,000 downtown to build the parking lot and the bathrooms there. So the city was well aware that there was a public need for that, and it's part of our permanent responsibilities to provide bathroom facilities in these high-traffic tourist areas. And lastly, I want to state that, for the record, there was a statement made by Mrs. Coburn about a blow-away structure, and her speaking to Mr. DePasqua. I have notes here from January 10th of this month, the 10th of this month, where Mr. DePasqua summarized his conversation he had with Ms. Coburn about a lengthy discussion they had about the conditional use process. He answered her questions concerning electrical, plumbing, bathrooms, wind load, etc. She was also told about the building permit process and the next steps that will be required that the applicant would have to follow should the conditional use be granted. And at no time did he say that these would be blow-away structures and would not need to meet all building codes.
Yeah, he's not here to state that. We understand that. Just like other people say things that other people say.
I would suggest that both statements were hearsay, yours and his.
Exactly. So you're done, Mr. Chapman?
Yes, sir.
Okay. Now we're going to allow the board to satisfy their questions. Ms. Van Arlo, I would like to begin with you.
No.
You have no questions or anything you wish to add?
No, I don't, thank you.
Okay, Mr. Jalous.
No questions.
Mr. Stavropoulos, we have questions.
I have one question.
This is questions part. After we make the motion, then y'all can make all the comments you want. But this is questions.
Yeah, it's a question.
Go ahead. You have the floor. Who you want to ask?
Rodney.
Go.
Yeah, Rodney, you had mentioned that these so-called kiosks were supposed to be Florida Building Code approved. I'm kind of questioning, what are all these structures are not
I
Florida
know
Code
that
approved,
the applicant has on their property the gazebo where the eucalyptus oil is. They received a building permit. I can tell you several of those on there. I'm not sure how they were constructed. I know for sure that the one, not to get too deep into that issue, but number 2 on the Leventus
That's what we're here for, Rodney, talking to the mic.
Oh, sorry. Number 2 for the Leventus property. Have no idea how that got there. That structure was not there when the city constructed the bathrooms. This board recommended approval of the site plan for the bathrooms, and I'm not sure when that went up.
So you're referring to item 2 on the, where it says Sunline Cruise ticket booth?
Yes.
And would you say it again? You say that's a new building?
Am I incorrect?
Is that what your statement was?
That's correct.
And that it had to go through the building permitting process?
I never approved, or myself, or I can only speak for myself. Mr. Vincent also reviews building permits, but I can tell you that I did not approve a building permit for that structure.
Okay. Go ahead, Mr. Stavropoulos. Further questions?
No, that was basically it. I overheard a statement, although from Mrs. Belair's, that these structures on her proposed on the property there, that they could be torn down and at some point. But if they're Florida Code building approved, it's a lot more difficult to tear something like that down.
Mm-hmm. Do you wish to comment, Mrs. Belair's, on his question about the buildings at some point may be torn down? Not necessary. Just okay. Go ahead.
That was it. Okay. That's just an observation.
Mr. Chambers, would you like to ask some questions at this time?
Yeah, I'd like to ask some questions of all, but
Go
starting
ahead.
with Mr. Chapman first. I think he might be able to answer some of these for me, and then we'll go through this. Mr. Chapman, I'd like to ask you questions on the exhibit from Ms. Colburn, list of all existing kiosks on Dodecanese. Number 1, is that a kiosk?
Excuse me?
Based on the code, is that a kiosk?
Yes, I would say it meets that definition.
Does it meet all the requirements for building codes and things like that in the city of Tarpon Springs? We're going to go through every one of these. There's a reason for this.
So you're asking specifically
Number
about
one.
number 1.
And I'm going to go number 2, number 3, and I want to know what a kiosk is, and I want to know what a building is by the time we're done with this.
Can I, in the spirit of timeliness,
I'll let you tell me which numbers you think are buildings and kiosks. So how about this? Let me just ask a question this way. All these kiosks that are here, 1 through whatever, and they have employees that work at these, correct?
That's correct.
And those employees work in these properties where sometimes they might go, I don't know, use other businesses, possibly?
Yes.
Do they use the restrooms there? Do you know that for sure?
I don't know for sure, but it's most likely that they do.
Because I would assume that they use the restroom somewhere.
Yeah.
So 6 people possibly working in a kiosk on a property would have to use the restroom somewhere.
That's correct.
Okay. So, number 6, Yanni's restaurant property keeps those Nick Bada Bing. Well, I respect them all. I'm going to ask about that kiosk there that Nick has with the roof not on it, and compare that against number 5 and the roof not on that picture that was shown to us as an exhibit, where in the Belair's property, the one that had the sponges but there was no tent over it, I guess.
Mm-hmm.
What's the difference between number 6, Nick Bada Bing, and number 5, the one that has that tent thing That's not up in that picture.
There's no material difference in the two.
Which is in violation of code? Based on the code as you know it today. Are they both?
Yes, there's different standards now for kiosks, yes. No one will be allowed to put up what Nick has there now or what...
Or Mr. Blair's has, correct?
That's correct.
Okay. Going on to number 7, that tiki hut that's in the middle of that parking lot. Is that adding any value to that property or taking away value from that property? Or number 8 for that matter, or number 9? Or is it, in your opinion, adding value to those properties?
We have the structures, if they were appraised, would have a monetary value to them, so they are adding some financial value to the property.
Thank you. And part of the conversation was that there would be possible adverse values to these properties should they place a kiosk on the property. I'm looking at number 7, 8, and 9, and I don't see how that could be determined. There's no trees there, correct? Number 7, 8, or 9, except for some basic landscaping that's further away.
Yes.
There's no beautification to the property that's been proposed.
That's correct.
So how would 7, 8, and 9 be approved today based on the criteria that Ms. Colburn set forth?
They would not.
Okay. How about number 10 and number 11? Number 10, I'm not really that concerned about. That's a structure, it looks like, with someone that put a top or a roof over it. There's a bottle, the snow cup thing there. Number 11, is that that's a kiosk, right?
Yes.
In the middle of a parking lot?
Yes.
With no greenage or sign, with plenty of signage, but no greenery or any type of shrubs or anything around it?
In the picture.
Right?
Right.
All right, so I apologize for making this long, but I think it's important. So I'm going to keep on going. Sure. Now I'm going to go to the staff report, and I'm going to go back to the pictures of the staff report. And we mentioned earlier that there's so many signs per property. Attachment B, I'm going to start with, the Pappas Prosper parking lot. I can't tell you what that sign is, but I think it adds value to it. There's 2 signs on that property. The next one is the snow cone thing. I'm not sure how many signs are on the snow cone one. It's like one with a multiple around it. There's 2 signs on the glass bottle art building because they sell glass bottle art and cheese putters there. There's about 7 signs on the Spongerama one. There's 2 signs on the sponge exhibit thing there. I'm going to try to keep on going in the right direction here. The bottom line to all this is that if we're talking about signage and how many signs are on the kiosk, the eucalyptus kiosk, I don't know. I've not seen the back of it, but I count 4 in this picture. Now, you told us earlier that one wall sign per establishment, correct? That's the code?
Yes.
Is there such thing as a grandfathering in?
No.
The reason I'm asking that question is that let's assume that this is approved today.
Mm-hmm.
And they go out there with all zealous and they start building these 5 more kiosks. They tear down 2, they keep this one here, and they build up 5 more kiosks. Are they going to be able to, because they had the previous building there that was made with these 4 signs and apparently only one's allowed to be there, going to be able to build 5 more buildings that are going to have 4 signs on each?
No.
I'm sorry?
No.
But they have it on the property already. And there's 7 on the Spongerama sign. This one on that page. I'm just asking for the reason that if we're going to make this be the thing of fairness, then shouldn't all these be the same? Regardless
That's
of...
correct, yes.
Regardless of whatever the outcome is today, shouldn't this be the same?
Yes.
Right. I'm going to keep on going. And I'm just asking questions. Now I'm going to ask about the restrooms for a second because that was the big issue last time, and it seems like it's a big issue this time. When we have events, Night of the Islands, or we shut down the thing and we put I'm going to call those things that are in the middle of the road kiosks that are in the middle of the road when we shut the road down.
Yes.
Are the restrooms overburdened?
No.
I'm sorry?
No, they're not.
The gentleman that takes care of the public works for the city, does he do this full time for the city?
Yes.
So when he did this report with you all, did he take all those things into consideration, the 6 employees plus the 2,000 people that come?
Yes. The city's wastewater treatment plant superintendent evaluated this request. He sits on the technical review committee. He had no concerns about the solid waste or sewer and water usage of 6 kiosks.
Okay. And when there was 21, what was his same evaluation of that?
He had no concern.
For 21 employees, but we're going to bring 21 employees into the town.
Plenty of capacity at the wastewater treatment plant.
Okay. Mr. Chapman, I want to make sure that I'm clear that I'm looking at the right event for tonight as far as what this is right here. This one, I lost pages to it. Hold on. Pardon me one second. Here we go. I want to make sure I am looking at the right thing and what it's called. This is the report for application 11-60 Belair's Partners.
Mm-hmm.
At any time during your meetings with the client, have they told you this is a flea market or an open air market?
No.
Have they applied for that in this application?
No.
Have they told you that if they get declined, they're going to go open a flea market?
No.
Okay. So, now, if they told you that, would that have any bearing on this application 11-60?
No.
Okay. Okay. I think I'm getting close to you, Mr. Cole. Thank you very much, Rodney. I think I'm done with Mr. Rodney right now. Okay, I'm sorry. Yeah, I do have one more for you, Rodney. Then I think I'm pretty much done, except for Ms. Colburn, if I can ask her a couple questions. What is the? And don't have to read it to me because we did that the last time. You don't have to read what a kiosk is to me,
Okay.
or an open air market building. I can read pretty well, and I hope everybody else can.
Mm-hmm.
What is the difference that Ms. Colburn is projecting that flea market and open air market keeps on coming up, and what the applicant is actually stating? Because I don't see how this compelling new information making me feel that this is going to have an adverse effect on this community. These are going to be flea markets, but yet there's nothing here that states it's flea market. And we're talking about kiosks. We have not talked about open markets at all as it relates to this application, nor have we talked about flea markets as it relates to this application. So, and I don't say it again, I'm just restating. Rodney, what am I missing? Besides the people don't want it. Besides, it reminds me of a book, pardon me for interrupting, it's by Spencer Johnson. He's a doctor who wrote Who Moved My Cheese? And a book basically about how when things are changing, the people that don't like it kind of sit around and wait for those changes to kind of hopefully they know happen and they just never do, and then eventually it was based on mice, actually. And the Who Moved My Cheese was these mice that would basically sit there and say the cheese is going to come back one day. The tourists are going to come back. We're not going to do anything different. We're going to keep the Belair's property looking exactly like it's going to look. We're going to leave these other properties looking exactly like they look.
Okay. Is there a question?
We're in the question portion. Okay. But the question is this. If this is not a kiosk and this is not an open air market, why does she think it is?
Probably a question better for her.
Okay, because you don't. Okay. All right, thank you. That's all.
You would like to answer that, Ms. Clemens?
Oh, yeah, I guess so.
A kiosk, unless they're tied to a main business, like all the ones that are in here, pretty much, are transitory retailers. They're transit retailers. They're not going to, you know, there are so many empty stores in the Sponge Exchange or marginal. They're not going to get people to sign a year-long lease for a kiosk. I mean, it's not going to happen. It's not reality. So it's going to be these fly-by-night types that are going to be coming and going in the kiosk. And that's what a flea market is. It's fly-by-night tenants, transitory retail tenants.
Okay.
So
Ms. Colburn, if I could just ask the question, then, because you're answering, that wasn't my question. My question is then, in attachment B or this attachment here, I just want to show it to you. This is transient.
That is the Tiki Hut, which the city approved.
But the Sponge Diving Exchange is considered transient. Possibly they could move on. They could not be there tomorrow.
The tenants? No.
Nick Bada Bing? Maybe not.
Nick Bada Bing is a push cart, as far as I can tell, and they're allowed with conditional use. I can't see them.
It's your picture. It's your same picture you gave us. It's a kiosk, right? All right. Just asking. Yeah. Is that a kiosk? I'm just wondering.
Okay, for the record,
I'm showing the picture in the backup page of the staff.
It's in our staff report. 1, 2, 3 from the last, and referring to that Nick Bada Bing Tobacco King, which is just like a metallic structure. So you would like to give your answer into the mic now, Ms. Clemens?
My answer is it's either a push cart or a kiosk, in the sense that it sells inexpensive consumables. There's also something they call, like the snow cone thing is sort of considered an appliance kiosk. It can be moved. There's different names for these things, but they essentially serve the same purpose, which is,
And the reason why I was going there is that based on the kiosk, an open kiosk, a booth that might have an open window, one or more sides, operates vendors selling small, inexpensive consumables like cruises and things like that, and glass bottle art, and expedition diving, and the items that you might be selling. What's the difference? If she sells cigars at her kiosk, what's the difference?
there is no difference, except there's 6 of them. So now you're forming a community, which is a market.
In part of this code, where does it say that that is not allowed?
It doesn't. It's with every single kiosk has to be approved by the city, and you decide what's too many and what's not enough.
The limitation, though,
That's right.
is based on.
You decide.
I know, but you made a whole case.
It's a common sense
one location.
argument.
Each one has one location. One has a couple has
Well,
two.
yeah, that's the de facto
Chairman,
city.
I object to the argumentative nature of the questions. This position is for us to ask questions of witnesses and to get information.
I'm trying to ask questions and,
not to argue.
Well, to respond to that, I think it's kind of back that regard. So, your question basically is, what's the difference between
what they're proposing
what
and what's already out there?
currently out there
Compliance.
and what Ms. Valeris has proposed?
I want to know.
The number of them in one place.
Okay, thank you.
Understand.
Okay.
The number. Go ahead.
So that's don't conform with the code. Open up market. Give me one more second. Thank you.
Any other questions? Should I stay up here?
No, I think we're done. Thank you. Yeah, Ms. Valeris. Ms. Valeris, may I ask you a couple of questions? Thank you, Ms. Goldberg.
Yes.
I guess my thing is that I'm kind of, the last meeting we had, you had some neat looking designs for these kiosks. I'm not sure if they were your designs for the kiosks, but these, quite honestly, are gazebos to me.
Actually, they're the same design as the kiosk that's down there currently.
Okay. These will
that
close then. These will close up and be permanent.
That company where you see an open railing, they actually build a wall to the bottom and then they make a booth at the other top half.
Okay, just for my...
I didn't know staff didn't include the plans for the other one. They did the last time, but it's a...
I just want to make sure, because I could see where there'd be confusion when we're looking at things and they're not closed off. So it's going to be, if for all intents and purposes, it's going to look more like the same that's already there? With modern...
Yes, except some changes. I don't know what the size of that one is, but there is one can be a rectangular and one can be an octagon, depending on the property.
Okay.
But not exceeding 10 by 10.
I'm not sure if this is Mr. Marcus, I'm not sure if this is going to be in the purview of what we asked, but your tenants.
Yes.
Are you signing month-to-month leases with them? I mean, I'm not sure if this is something I can ask or not.
Well, I don't think it's a purview, but I will tell you that we are doing annual leases.
And what happens if they break their lease? I mean, they're going to pay some money to you, I guess?
Yeah.
You're going to find another lease? Okay.
Yeah.
All right.
There'll be a fine implemented and
okay.
They force
I don't
that
think
whatever.
that's my business to know that, but I just wanted to just get an idea of it. Are you concerned with the use of restrooms?
No.
They keep on calling you your employees, but these aren't going to be your employees.
No, they're not my employees.
They're going to be your renters or tenants?
Well, if you kind of look at it a little bit differently, I don't think, number one, they're going to be operating their business down there most of the day, probably from 9 to 5. I believe they're going to want to eat lunch. And typically they'll use one of the restaurants to eat lunch and typically go to the bathroom when they go to lunch. But other than that, there are public bathrooms for them to use. I don't think it's an overload on the bathroom.
Is your parking lot going to still be used as a cave for parking, or is that going to be for the parking for those tenants?
That will be still pay for parking in the back.
Okay. As far as the signs go on this thing, are you going to be complying with the code?
Comply with code.
On the current one that's there, the eucalyptus one, will that one fall under the same thing?
Soon as everyone else does.
Okay. All right. I think that's all I have for right now.
Thank you.
Thank you.
Mr. Vinson, did you have questions of any of the applicant, intervener, or
No, thank you.
provide testimony?
Mr. Vice Chairman, can I ask one question of Rodney?
Yes, you may.
I have a question is simply, could you tell us your qualifications as a planner?
I have a master's degree in planning from the University of Florida. I have my certification from the American Institute of Certified Planners. I have been here with the city of Tarpon Springs in May, and May 10th, it'll be 10 years. I was part of the staff that drafted the Smart Code and Special Area Plan. I have various duties and responsibilities here with the city, including staffing this board, the Board of Adjustment. I have also staffed the Heritage Preservation Board. I stand in for the Planning Director before the Board of Commissioners for other items. I also have managed several projects to include 4 landscaping projects, and I'm currently one of the project managers for the Sponge Docks Improvement Project.
The opinions you rendered here today have been based upon your education, training, and experience as a planner?
That's correct.
Okay. I just would like to clarify a couple of things here. Mr. Chapman and Mr. Yakubon, I guess maybe. It was stated by Ms. Coburn that the city in site plans require landscaping, and that there isn't any landscaping on this site plan that would normally accompany a parking lot or another type of site plan, and that the easement is a method to escape that requirement. Can you clarify, Mr. Chapman, that by the easement and the buffering that is being provided in the easement, that it meets the requirement, or am I wrong in that?
Yes, it does meet the requirement.
Thank you. Anywhere in the code where it talks about kiosks or any kind of structures in this similarity, it doesn't mention quantities, does it?
No, it does not.
It was mentioned earlier that one of the options the applicant would have if they didn't put the kiosks in would be a regular flea market. Now, Ms. Coburn provided us a kind of a crib sheet for a specific function and use. But I'm from my previous recollection, I'm thinking that this is only part of that chart.
Yes, there's another sheet.
So it was referred in the testimony that flea markets or that type of entity is something currently allowed.
If you look at the open market building definition, which it describes flea markets, farmer markets, and similar operations, that is a permitted use in the SDB, which is the area where the applicant owns. This is the subject property.
Okay, but you're referring to
if you look up about
open market building?
Yes. Mm-hmm.
Okay, but I'm not seeing, and I just want to clarify because reference has been made that it's allowed in the code to put a flea market, and I'm not seeing it in this list, so I just want to make sure that.
Yeah, just for a bit of clarification, in the definition section of the Smart Code, Chapter 6, an open market building is described as a retail sales establishment operated under a fixed permanent roof structure, which may or may not contain walls, and these are limited to farmers market, flea markets, food vendors, and the like. So our interpretation of that definition would classify an open market building such as a flea market as a permitted use.
So in essence, if they were to, I guess the issue seems to be, well, if they were to go in and build a building with a roof and some bathrooms and no walls and the rest could be flea market, everything would be hunky-dory.
Yes.
Okay. I think that's, Miss Athena Clemmis, and she left already? Okay, well, I told people to leave for questions. Mr. Kalouris, you can come up to the stand, please. You mentioned that as a representative for the Pappas Sponge Exchange, that you were concerned about the applicant not having dumpsters and bathrooms and such of that nature. How does that affect you?
I believe the bathrooms, being that there's two public bathrooms on the Sponge Docks, one being the one that y'all just built, the second being that you guys subsidize us as ours. Ours is closer to the Blair's property. I believe their tenants will use ours before they walk past ours to go use the city's.
Okay. So, I'd just like to clarify something. You're saying ours, and yet you say the city subsidizes. So the city's giving you money to provide bathrooms open to the public. So you can't discriminate, can you, between who uses the bathrooms there? You can't say, oh, well, you went to Five Fish, or you went to the ice cream place, or the glass place. You can go use it, but somebody else, because the city provides you money to allow the bathrooms to be open, correct?
I cannot.
Thank you. You mentioned maintenance of property and past history. How old are you, sir?
27 years old.
Thank you. You can sit down. Ms. Clemmis, can you come to the stand, please? Or the podium, please. Yes, please. Or Coburn, I'm sorry. It says Coburn, sorry. No, I see you, and I think Clemmis, I'm sorry. I know, I have to. In your closing here, you made a remark about these structures hiding the waterfront.
Mhm.
Blocking the view.
Right.
If they built a 3-story building, would people on the street have access to a view of the waterfront?
No.
Thank you. Sit down, please. All right. Any other further questions of the board? Public comments. Debate is closed. Chair will entertain a motion.
There's no more. We're done, right? Okay, I just want to...
Unless you got more questions or stuff?
No.
Take a motion, and...
I'd like to make a motion to accept application number 1160, Balearis Partners, as been proposed by staff. Second the motion.
Okay, so... Karen, you have that? Chambers and Jalousis. Okay, Mr. Chambers, you made the motion. You may begin with your statement as to why you feel the motion should be carried.
Well, I was hoping that Rodney would be in the room, but he's left, and based on the criteria that...
He should be back.
Yeah, based on the criteria that's put in front of us here, and based on that, the questions I asked and that were answered, I feel that this should be passed because it doesn't do the things that are being opposed to it.
Okay.
That is it.
Mr. Jalousis, you seconded. Would you like to make any comments to the motion?
No. Let's
Say again?
get on with it.
Okay.
Get
Ms.
on.
St. Arnold, would you like to comment to the issue?
I think this would be an added thing for Tarpon Springs. I have seen kiosks all over the world, and they've been a good thing, not a bad thing.
Thank you. Mr. Stavropoulos, do you have any comments or anything you'd like to add at this point? Mr. Vinson, it's your turn now.
Thank you, Mr. Chairman. I see good points made by both sides of this issue, and so it's, for me, not an easy matter. The drawing that I presume an architect did that was in the packet, it looks very nice, and of course there's only 2 kiosks drawn here in this drawing, but of course a lot of times things don't turn out like the architect draws them. But I think those type of kiosks are obviously much more attractive than the photos that we've seen in our backup or in our presentation today. And I'm not really too keen on the gazebos that were provided here from the company that does gazebos, which I guess this one that's on the Balearis property, the eucalyptus oil, I guess, is done by that same company. I don't know if it's a paint job or what. It just doesn't seem to be that attractive. It's important, well, first of all, let me say, Mr. Balearis, I don't think anybody can look at what you've done for the city all these many years and say and criticize you for that. I don't think anyone's doing that, and I didn't hear that tonight. And certainly, I have the highest respect for your efforts on behalf of the city over these many years. And I think that the issue is a difficult one for me because I would like to see things improve in the Sponge Docks area as well as in downtown as well. And I've heard concerns of some of the business owners that have spoken tonight, and some of those concerns are valid concerns. It's one of the issues that I don't think that we really have a good answer. We don't know what's going to happen. I mean, we've got plans. I certainly like the amended proposal much better than the one last month with the 21 kiosks. I think it does shield the cars somewhat depending on the landscaping, and hopefully, although it is nice to be able to see the river, but if you're just looking at a lot of cars, it's not too attractive. I'm concerned about the easement issue, and that's why I raised that question early on. That I frankly haven't heard of an easement being given as a revocable easement because that's sort of like illusory of any right if someone can just take it back, when they want. I think if there was a change, if it was a perpetual easement, and the Balearises needed to do something with the property that I think they could certainly ask the city, and the city would have the power to give up their easement that had been given to them if it was a good reason to do that. I have concerns about the idea of a revocable easement, especially when we really don't have any, other than just a brief comment about the conditions for that revocation. We don't have a copy of the proposed easement in our backup. We didn't have a copy of the application, which may have answered a lot of questions. That would have been helpful, I think, in this case. But think overall, I'll probably support the application as it's been amended for the 6 kiosks along the front with the landscaping, because I think it's a lot better than it was, and I think it will improve what's there now, and so for that reason, I'll vote for it.
Thank you, Mr. Vinson, and I'm sure as you're aware, if you would like to have the motion represent something of your concern about the type of easement, you can ask for an amendment of that, because as it stands, just for clarification, what we would be accepting would be the amended recommendations that are on page 7 and 8, items 1 through 6. So if you feel that that's something you wish to amend, we can move on that at some point if we get some.
Well, I understand that, Mr. Chairman, but the staff recommendation, the number 5 that deals with the amendment, just says the applicant must grant the city a 10-foot landscaping and pedestrian easement along the front property line within 30 days of approval. I trust that the Board of Commissioners may be aware that that's an issue. They're the ones that have the final say, but so I can live with the recommendation as it is.
That's a fair point. Anybody else on the board have anything else they would like to say? Okay, I'm going to say a few things. I've sat on many boards, and there's people out here who are probably going to be pissed at me. Pettiness. Too much pettiness. Pettiness. Okay, we're here looking at basically a conditional use request to put some structures on the property. The requests are for 6 kiosks in the alignment that we've been shown. As we've heard from staff, there are no requirements for what is being presented, that they have to provide restrooms. Yes, we all would like that to happen. But I don't see where, as the applicants have said, 6 people are going to create that much of a strain. The people that will be hopefully patronizing their places will hopefully be patronizing your places. And you know, even at the last meeting where we kind of got into minutia about small, inexpensive convenience items. You want to know something to me? That's BS. I know that's in the code, and that's how some people out there are going to be watching them. But as Ms. Belair said, and I believe this also, it's diversity. And if she and the applicant, Mr. and Ms. Belair, can provide diversity to draw different people down to the docks, everybody will benefit. Now, one of the things that I thought was kind of key, you know, I've had issues with the time frames. Originally it was 7 years for 21. Now it's 3 years for 6. And I'm thinking, well, geez, you know, you should be able to do it less than 3 years. And I spoke to staff, and I'm going to tell you the same thing they told me, so y'all are all clear. Once they pull the building permit, as long as they keep doing something every once in a while, they can be there 10 years, 20 years. So they're doing you a favor by saying they'll be done by a certain time. There's a commitment to be done, not something that's dragging out. In the staff report that we received on page 7, where it says such uses are in fact desirable transitional uses for the surface parking lots that are an eyesore and do nothing to promote local, regional, or out-of-state tourism. Transitional. You're all looking at kiosks. Oh, well, they're only going to be there a little while, or they may get blown away. Yeah, that may happen. We can have a hurricane take out the rest of the docks, and where will everybody be? Y'all will have to start building code, signage from scratch. No more grandfathering. No more grandfathering. And you know, this thing, well, they're going to put all these signs and then get down the other side, everybody's getting away with everything. You know, it's like petty. It's ridiculous. And Mr. Beliers makes a valid point. The more each of you do to draw people here, the more all of y'all will benefit. And we may not like kiosks. Some people are afraid, well, they're going to sell the same thing that I'm selling. That's already happening now. How many shops can you go in and buy shell necklaces or bamboo hats or sandals and T-shirts? So, to be honest with you, I hope she sells things other than the same thing that y'all are selling, that y'all are worried about the competition. So at this point, I don't really see anything, I didn't see anything from the intervener to indicate that her clients had any more of a compelling injury than anybody else on the dock, or anybody else in the CRA for that matter. And I would have to say that the judgment of property values as to whether it hurts or doesn't hurt without either side providing some sort of a logistical report going back 10 years verifying data to state, well, these uses have shown these properties have increased, or these uses have shown these properties have decreased. So both sides didn't show me that it's going to affect the property one way or the other. Although I do believe in common sense that if you, as Mr. Chapman pointed out, you put structures, you do things to improve your property, then that does not only improve the applicant's property, but also the surrounding. And to be honest with you, even though you may not like these kiosks, from what I've seen presented that will be going on the property, are much more stable, much more secure, much better looking than I would say about 8 to 10 of the other ones. The one in front of the Lowe's, the little grass hut, please. So, at this point, I'm going to ask Madam Secretary to call the roll, and I would like it called in least seniority to most seniority, because that's how we should do it. Alternates go first if they can vote, and then I thought we had one. No, we did some change at the last meeting. They moved Mr. Chambers to permanent, and we still have one alternate. Mr. Stavropoulos is, I'm sorry, I don't want to. Mr. Chapman, can you help me here? Are we all board members here, or we have any alternates?
Yeah, we're all members.
We're all permanent.
Mm-hmm.
Okay, so least seniority. So who was last on? Mr. Chambers was last on? I guess so. And then Mr. Stavropoulos. Then Ms. St. Arnold, Mr. Jalousis, Mr. Vincent. We can proceed.
Okay.
Mr. Chambers first.
Mr. Chambers?
Yes.
Mr. Stavropoulos?
Yes.
Ms. St. Arnold?
Yes.
Mr. Jalousis?
Yes.
Mr. Vincent?
Yes.
Mr. Blackus?
Yes.
Did I get that order right?
Yes. Seeing that it's 10:35 and we have another applicant, we will now proceed to oh, wait, I can give the gavel back to Mr. Franzese. There you go, Ted.
Now, we have to move on. Okay, yes. This is application, 12-65.
Thank you.
Vercor, LLC. Is there any ex parte communication relative to this? Okay, seeing none, Mr. Chapman, you're on.
Thank you, Mr. Chairman. This application is for conditional use for what we will call for the purposes of the Land Development Code and Arcade. We don't have, and the reason it is as such, is we don't have a use classification that neatly fits into what they want to do. This board has heard applications for a similar operation in the past, and I'll go into further detail as to the type of use. The property is on U.S. Highway 19. It's zoned highway business, and what they are asking for is approval for an internet sweepstakes cafe. And I'll just briefly go through some of the background. And in general terms, these cafes advertise and sell a product. Sometimes it's internet time or long-distance telephone minutes. Along with the internet time, the customer may receive bonus entries in an internet sweepstakes. With those entries, the customer can participate in internet-based games at the cafe's specially programmed personal computers. And based on a random allocation of winning and losing entries, the customer may or may not win prizes through the game. The applicant would like to open such a business, and the type of the use would be limited to persons age 18 or older. As far as standards for review, it is a conditional use in the HB zoning district. The code is silent to any additional standards or criteria that are specific to this type of business. As far as compatibility, the subject property is in a proposed strip mall on US 19. The properties that surround it are a mix of commercial uses. There's a Domino's Pizza, there's a law office, a nail salon, a Mexican restaurant, and even a hotel and mobile home park in the general vicinity. We feel that the proposed use is compatible with the existing and planned uses on the city's main commercial corridor. We determined that it is consistent with the comprehensive plan. We did not identify any adverse impacts to the environmental or historical resources associated with the application. We did not feel that it would negatively affect adjoining property values nor exceed the city's ability to provide appropriate public facilities. And we felt that this request would have a positive impact upon the future growth patterns along the section of US 19. You see the TRC comments that were made at the November 29th meeting, and just a little bit more detail on that. We as the planning staff reviewed the Florida statute that regulates and governs these types of operations. It's referenced there in our comments, chapter 849, And after our TRC meeting, there were conversations between the police department and the city attorney to ensure that what we were getting was consistent with that statute. Our police department, after consulting with others, did not have any objections to what they want to do. We did properly notice the application and have not received any phone calls, letters, emails on this application. The staff recommendation states as follows. The approval of the conditional use is based solely upon information submitted by the applicant that is relevant to the criteria for evaluating conditional uses set forth in the Comprehensive Zoning and Land Development Code and does not constitute information or approval or an opinion whether any aspect of the present or future mode of operation of the business violates Chapter 849 Florida statutes or any other provision of the Florida statutes. The business must operate in compliance with Chapter 849. You have a photograph of the storefront. those of you who know that strip center used to be, I believe, the Sinful Bites Cafe. You also have a description of the business that was prepared by the applicant, as well as a floor plan that shows the layout of the interior of the storefront, which identifies, I believe, tables, computer stations, and chairs, and so on. And you also have a copy of an area map, an aerial photograph, a copy of the zoning map, and the future land use plan map. And with that, I'd be happy to answer any questions you may have.
Okay. We'll start, Mr. Stavropoulos, do you have any questions?
Well, this facility is very similar to certain other facilities in that area, in terms of this type of activity. So, I mean, I don't see any issues with that type of a service.
Okay. Mr. Chambers, do you have any questions for staff?
I'm reading the code on it. Can you come back to me? Just ask me if I don't think I will, but just want to make sure.
Yes, Mr. Delagas.
I just would like to maybe get a little more feedback from the city attorney, where in the staff report says the police department will consult with the city attorney and the Pinellas County Sheriff's Office. And other than client-attorney privilege, what can you share with us, Mr. Iacovone, as to where this type of business relates to us in a sense of approving a conditional use, even though there seem to be, I guess, larger outstanding issues?
Well, the issue, the question directly is just gambling. We can't obviously approve a use that violates the Florida statutes, and that is an issue in the state of Florida. The legislature has not spoken on it with any clarity. Some governmental entities and authorities have taken a position that is gambling. Some have not. Pinellas County Sheriff's Office is one and has enforced it in the county has brought several actions, actually has charged them with crimes. But so far, as I know, there's no civil decision in the state of Florida indicating that these constitute gambling, and that is a more subtle question. It depends, I guess, to a large part on the mode of operation. The city has not, my office has not taken a position yet, and I think the administration has not taken a position yet. So at this point, I think I came up with the wording for the staff recommendation, and that is to serve notice that they provide us a description of what they do in granting this conditional use. We're not vouching or affirming or ratifying or rendering any opinion that their present or future mode of operation may not be determined to be gambling and then for unlawful. But at this point, it's unclear. So in litigation that arises out of this type of stuff, and there's a boatload of it, I won't go into the details, but many of these businesses are very litigious. One aspect of one of the things that they have argued is that by approving the use, we're approving the activity. And so this statement very clearly states that by approving the use, we are not necessarily approving the activity. And so it's more to prevent the city from being forestalled of taking action in the future if and when it is, if, when, or ever it's determined that their operation or a particular mode of operation is determined to be gambling.
Okay. And then as a conditional use, if they present us an operational plan, which, I'm not really seeing a full operational plan. I'm just seeing kind of a sketch here, but if they don't follow that operational plan, then they're not complying with the terms of the conditional use such that the conditional use could be revoked, correct?
No, they don't necessarily, it's not, well, they're telling us they're going to operate this way. In essence, they're saying we operate legally. The last paragraph, actually most of this letter, I think, is calculated to say what we do is legal, here's how we do it, and it's legal. And the next last paragraph says, in compliance with the alternative mode of entry as required by Florida Statute 894.094, there's no purchase necessary, et cetera, et cetera. So they're going beyond what the city really needs to know to approve the activity. And so all we're saying, or the staff is saying, and the city is saying to them is that, look, we're approving the business, but we're not necessarily signing on to the language in this letter where they say what we do is legal.
Okay. And I just wanted to clarify, because I think you made an important point, that by approving the conditional use, we're not approving the particular business or operation. We're just approving that they can operate under the current statutory guidelines.
At this point, we don't know whether it's going to be determined legal or not.
Okay. That's all my questions at staff. Thank you. So we don't know.
Mr. Vincent, questions to staff?
No questions to staff.
Mr. Jalusis?
So we don't have to consider the question of whether the gambling is legal or whether it's gambling or not. We're just making a decision based on the business model.
Right.
Okay.
Yeah, we don't know whether it's legal or not.
Mr. Yanor?
No, thank you.
Okay. I don't have any questions. Can we have the applicant now? Any other questions? George?
No, I've got the answer.
Okay, you're okay?
Yes, sir.
Can we have the applicant come up, please? I want to thank you for your patience. It's been a long evening. Please give us your name, address. If you can.
Good evening, everyone. My name is Virgilio Plantilla, 330 Appaloosa Road, Tarpon Springs, Florida. This is my partner, Courtney Gross. We are requesting conditional use approval for Arcade Internet Cafe at 39208 US 19, Tarpon Springs. I brought myself, my partner, my agent, and my sweepstakes attorney from Tallahassee, Mrs. Miriam Wilkinson. If you have any questions about the legality of what we do, please feel free. We have a big store in Clearwater. We've been approved by the City of Clearwater. We are doing great business, and I would like to bring the same amount of business to the City of Tarpon Springs.
Okay. Can we also have the attorney come up, please? In case there are any questions, please give us your name and address.
My name's Miriam Wilkinson, 1645 Metropolitan Boulevard, Suite 2, Tallahassee, 32308. And I'm with the law firm of Mathis and Murphy, PA.
Okay, thank you. We'll start with questions. Mr. Stavropoulos, do you have any questions?
I have no questions at this time.
Mr. Chambers, do you have any questions?
No.
Mr. Zalaki?
No questions.
Okay. I'm not sure who would answer, but in the letter we have of our brief description, it says, for every penny spent by our customers, Vorcor gives away free entries which entitle our customers to participate in our games promotion conducted on the very same computers that our customers use. When you say every penny spent by customers, what are they spending their money on?
The business sells blocks of prepaid internet access, and for every purchase, we give a certain amount of free entries so the customers can participate in our games promotion or sweepstakes.
Okay, so you say you sell internet access.
Yes, sir.
How do you sell that?
Mr. Delagus, I'm going to have to interrupt you. I think we have to take a vote to extend the meeting.
Go ahead.
I need a motion to extend the meeting. Let's go, Rodney, can you think we can be done by 11:30?
Yes, sir.
Okay, I need a motion.
Motion to extend to 11:30.
Okay, second?
Second.
Discussion? Okay, let's take a roll call.
Mr. Chambers?
Yes.
Mr. Delakis?
Yes.
Mr. Giulice?
Yes.
Mr. Stavropoulos? Yes. Ms. St. Arnold? Yes. Mr. Vincent?
Yes.
Chairman Francis?
Yes. Okay, sorry, but that's something that we have to do. We have to get a vote to extend the meeting. So,
Just to 11:30, correct?
yes, just to 11:30.
Thank you very much.
Mr. Chairman, did you hear that? Okay.
All right. So again, the question is, you're selling blocks of internet time. How much
Yes, sir.
and how do you do what? Like
The internet
10
time
minutes
is
for
$10
$20? How do you
per
do it?
minute. 10 cents per minute.
10 cents per minute of
Per minute.
computer time.
Yes.
So how does that work? Someone comes in and says, I want to be an hour on the computer, and they give you
Or we
$6.
give them the equivalent of 1 hour.
Say again?
We give them the equivalent of 1 hour of what they want.
Right. So they give you $6, and they have an hour of internet time.
That's correct, sir.
So they can do anything they want on the
They
internet.
can do anything. They can browse the internet. They can check their email. They can visit their Facebook pages. They can do anything. They can even go shop online, whatever.
Okay. So
And we do block certain sites. Strictly no pornography.
okay. So they paid you $6 for an hour of computer time, and where is it that quote unquote these sweepstakes come in? How is that tied into?
To promote our business,
Okay.
we do our games promotion just like you go to McDonald's. You're gonna buy your cheeseburger and your fries, and you get your free entries on their Monopoly game. The same thing, only we do this electronically.
Okay. So let me
And
just
the prices are predetermined.
Okay. So just to clarify, someone would come to your business to buy an hour of computer internet time for $6 because you're going to give them little scratch-offs or some sort of sweepstake coupons.
We do not give them scratch up per se. We actually give them free entries.
Free what?
Free entry points so they can go to the sweepstakes promotion page and redeem and find out if they won a prize or not.
If you're you look confused, I think I could help you.
Well, I understand the selling of the internet time, and you're getting $6 for an hour, and y'all are. He refers if you buy a hamburger. I mean, I read it there, and you're going to get some sort of like a Monopoly ticket.
The business model for sweepstakes, all sweepstakes. I'm the former Assistant Director of the Division of Consumer Services at the Florida Department of Agriculture and Consumer Services. We are responsible for the regulation and enforcement of sweepstakes and game promotions throughout the state of Florida. This business model is just like every other business model. And what I mean by that is when you go to McDonald's and you buy a Coke, now you used to get a paper game piece, but with the advent of the internet, you now get an alphanumerically coded entry, usually on your food container or your drink cup. You take that entry off, and what they tell you is they give you a web address that you can go to. You can input that alphanumeric code, and the website will determine whether or not you've won a prize. And as you know, I'm just using McDonald's as an example, but there are thousands and thousands of these game promotions that are filed annually with the department. They have a finite, pre-configured pool of prizes. So in the Monopoly game, you'll have 1 million Cokes, 1 million French fries, 1 million hamburgers, and $1 million prize. And then all those prizes are distributed at the different stores. So the pool is predetermined. And every time somebody gets a French fry, wins a French fry, and they redeem that, then the pool of French fry entries is depleted by 1. So as you have people winning, the pool gets depleted until all the prizes are awarded. And that's the law in Florida under 849-094 that was created in 1971. A sweepstakes is a game of chance conducted in conjunction with the sale of consumer products and services, in which the elements of chance and prize are present. No purchase is necessary. That's the law. If you pay, because gambling is prize, chance, and consideration, i.e. money. You're paying for the chance to win a prize. That's a slot machine. That's a lottery. You're paying for the chance to win a prize. The Florida legislature said in 1971, games of chance with a prize in Florida are lawful, but you cannot force somebody to pay for them. So businesses that sell products and services and want to drive foot traffic to their business and stimulate the sale of their services and their products employ game promotions. Everyone does it. So in 2006, we first saw these when they approached the department and said, we have this business model. This is like McDonald's. We want to do business, and we want to do it here in Florida. And 3 attorneys vetted this over a period of 6 months, and I was one of them because that was my program. And then I was promoted to assistant director. Before Commissioner Bronson would approve this particular business model, he required that we consult with the Office of the Attorney General, which we did. I have the original memo from December of 2006, where the Attorney General's office has been consulted and essentially said, this model appears to fit under the sweepstakes statute. We don't have an issue with it, and the department is the subject matter experts on this anyway. And so from that point forward is when people with this particular business model started coming in, which was in early 2007.
And how is the, you say they go online, they enter these numbers in, and they win sweepstakes. So it sounds like somebody else is awarding the prize, not this business.
No, that would be from McDonald's. You would get on their site. In this particular model, what happens is that a customer will walk in, will buy a certain block of internet access time, and they get free entries into a sweepstakes. Say they're awarded, for example, let's just say 100 free entries into the sweepstakes. They have the choice, and these are all alphanumerically coded entries. They have the choice of asking the cashier to tell them immediately whether or not any of those 100 entries are associated with a prize. So maybe entry number 10 is worth $5 and entry number 99 is worth $1. That's $6 total that they've won. And those 2 prizes will be pulled from the pool, and the pool will be depleted by $6 because it's a finite pool, and they have to award all the prizes offered.
Whose pool?
this is the operator's pool of prizes. They construct the pool, and then they award the prizes. And you have to award all the prizes by law. You can't refill the pool before all the prizes have been awarded.
So is the pool replenished by the people buying the internet time?
No. There's no relationship.
So where's the pool money coming from?
It comes from the operators.
Which operators?
Whoever, the business owner. The pools come from the business owner.
Okay, so the business owner devises the sweepstakes, sets up the odds, and then sets up a separate pool?
No. Typically what happens is this. They will license software. There are software manufacturers out there who specifically manufacture sweepstakes software. The particular software that these folks are using has been examined, certified, and tested by Nick Farley and Associates, which is the same third-party firm that certifies the slot machines in Broward County to make sure that they're running the way they're supposed to run. The software has, it's about a 200-page report, but in essence it says that it operates like a sweepstakes, not like a slot machine, not like a lottery. So they license, the software is licensed, they hold the license, and then when they get their entries, they're 100 entries, okay? Remember, there's 2 winning entries in there, a $5 entry and a $1 entry. So they can sit down at the computer and they can play video games that will incrementally reveal those 100 entries, okay? So if somebody doesn't want to have the cashier tell them if they won right away, they can sit down at the computer and they can incrementally reveal by playing video games. The contention, and this has been an issue from the day that the department said these are sweepstakes. I have talked to I've talked to law enforcement in every county, almost every municipality in this state. I've talked to legislators and city officials and county officials. And, some of them have expressed concern that, this is gambling because of the display. Because some of and not everybody has, not everybody has the same displays. It depends on the software manufacturer. But they have typically the spinning reels, and then they play, these video games. Not all of them look like video display on a slot machine. Some have different kinds of games like, Tetris or something similar that is like an arcade game. So it just depends. But, I think that's the heartburn. The heartburn is in the display. And, what I have told when I was with the department, what I said over and over to law enforcement, is if you think that this is gambling, you need to go in and do a forensic examination of the software and the equipment and, make your case. But there is no way for the business owner to manipulate the software because they don't have any access to it. It's a licensed product. So there's nothing that they have to do with that. They just simply license it. And it's just there on the computers.
Mr. Chairman, as interesting as all this is, I don't know how any of this is relevant to our question about the business model. I mean, when someone wants to open up a car wash, we don't ask them what kind of soap they use, what kind of machinery applies to the cars, how they get blown off and dried or waxed. I don't understand that. As long as you know, we're not passing on whether or not it's a legal operation. That's not our purview, and it's not the scope of our decision tonight. I don't know why we're spending time after 11 o'clock listening to this, although it is educational, I appreciate that. You explained it very well.
I just wanted to get an idea of how they win the contest.
Can we move on? I mean, are you happy?
You can control what she says.
Go ahead. Sure.
I asked my question.
I'm happy with what she said. Mr. Vincent?
I'm happy too.
No, I don't have any questions of the applicant. Thank you.
Mr. Jalusi?
No questions.
Mr. Arnold?
No questions.
Mr. Yakavon, do you have any questions?
I got lost somewhere. Greater minds than I will have to figure that one out.
Excuse me, Mr. Chairman, would you like to have a copy of the original memo regarding our discussions with the Attorney General?
I'll take your word for it myself.
Again, with our disclaimer, I don't know if that's relevant.
Okay.
If anyone wants to look at it?
Okay.
Okay, thank you. Can we, is there anyone out there who wishes to speak against this application? Is there anyone who wishes to speak for it? Please come up to the lectern. Give us your name and address, please.
Good evening, Mark Cersei, 9199 Mississippi Run, Wekiwati, Florida. I know it's late, and I appreciate your time. I'm a real estate agent working on behalf of Mr. Plantilla. I've known him for several years, and when he came to me originally and said, I want to put one of these businesses in the city of Clearwater, that little bitty town down the road, which is not you, I went to the city manager, the city attorney, Pam Aiken, the chief of police, very transparent, walked in the front door and said, okay, this is what my client wants to do, and they actually had a work session, city council meeting, they vetted my client, police background check, and they said, hey, we have no problem with what he's doing at all, approved. A week later, code enforcement walked in the door. They just wanted to check and make sure. And the code enforcement people said, your client's doing such a good job, we want him to open more in the city of Clearwater. He's an upstanding citizen, a resident of the city of Tarpon, and a straight up guy and a good businessman. And I think he would benefit the city very well.
Okay, thank you. At this point, I'm going to close the public portion and entertain a motion.
I'll make a motion that we accept the application 12-65.
Okay. You have a second?
Second the motion.
Mr. Julius, second. Any discussion? Call for the question.
Mr. Chambers?
Yes.
Mr. Delacus?
Yes.
Mr. Gialusa?
Yes.
Mr. Stavropoulos?
Yes.
Ms. Arnold?
Yes.
Mr. Vincent?
Yes.
Chairman Francis?
Yes. Best of luck to you. Thank you for your patience. Mr. Chapman.
Thank you, Mr. Chairman. The next two items are amendments to the city's comprehensive plan. The first is, for those of you who've been around for a while, it's our annual update of the capital improvement schedule of the capital improvements element of the comprehensive plan. For those of you who are new to the board, back, I guess, a couple years ago, well, the one brief, quick statement. Every year, except last year, the legislature always tinkers with the state growth management laws. So every year they find a way to give us more work to do. So a couple of years ago, they came up with this idea that we need to start taking the city's adopted capital improvement program, that's part of the annual budget, and then take those projects that are related to growth and level of service, take those from the capital improvements program out of the budget and put those into the capital improvements element schedule in the comprehensive plan. Just really a check the box kind of thing. So what you have here, and we've been doing this for several years now, is the growth related projects that are in the city's adopted budget for fiscal year 2012 through 2013 through 2016, 2017. Table 11 are our transportation or MMTD schedule of projects. I'll just kind of briefly go through these. Spruce Street Extension under design, will begin design. There's money in 2014-15 for some pedestrian improvements along Ashland Street. There is money to construct the extension of Eleanor Industrial Boulevard in this current year. There's money for the Pinellas Trail extension that would leave the Ankle Nature Park and go all the way up to Eleanor Industrial Boulevard in 2013, 2014. And then every other year we budget money for sidewalk improvements, and you see those figures there. 12 is recreation. So you see there's the replacement of the Discovery Sports Complex playground, the playground equipment at North Ankle Nature Park in 2014-15, Craig Park in that same year, the Stafford Live Oak project in this current year, Community Sports Complex planning activities in the current year, Tot Lot replacement at North Ankle Nature Park, and playground replacement at Highland Nature Park and Craig Park. 13 is the infrastructure schedule, and that deals with water, wastewater, water mains, several projects there. I'm not going to go through and read all those. And that's it.
Okay, and the reverse osmosis plant, is that on go now?
The
reverse osmosis?
The water plant, yes. I was told by the project manager that the second-ranked firm dropped their protest. I was on the evaluation committee for that design build project, so we kind of knew that they were going to do something because they were the only bidders that were actually in our meeting. And since they weren't first, we kind of had a feeling that they would protest. Nothing to it, so.
Okay, any questions for Mr. Chapman from anyone? Okay, do we have to vote on this? Or?
Yes.
Okay. I'll entertain a motion.
Motion to approve ordinance 2013-03, amending the 5-year capital improvement schedule.
Second.
Good. Any discussion? Seeing none, roll call.
Yes.
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 Yes. Mr. Chapman.
Okay. What's next is ordinance 2013-02. What I had left for you, if you go through the document, you saw that I had referenced that I would give you the updated work plan schedule for the next 10 years for the water system, and that's what I placed on the dice for you for tonight's meeting. But essentially, this is another one of the statutory requirements that the legislature has deemed that the planning department do. So back in 2008, for those of you who recall, we drafted a water supply facilities work plan that set forth data and analysis to demonstrate that we have enough water for the next 10 years to serve our citizens. So that was reviewed by the jurisdictional agencies, and we made a few revisions based on their comments, and we adopted our version of the water supply plan back in 2008. The Water Management District revised their plan, and the statute says that once the Water Management District in your areas revises their plan, you need to revise yours based on new data and new information that was in the new plan. This is the new plan for the region for water supply. It doesn't really affect us because we had been well along through our water supply planning activities, being the reverse osmosis water plant. So what you have before you is our updated 10-year water supply facilities work plan. they made some changes to population projections and the population within our water service area. I made the changes based on our, not to get too technical, but we used to have a different water use permit because we only had 3 or 4 active wells, but now with the RO plant, that permit has been amended to pick up all of the new wells as part of the RO plant. So, long story short, the schedule demonstrates that, we have the financial ability to fund the construction operation of the plant, and the plant will generate enough water for us to have quite a bit of a surplus of drinking water.
So we'll be able to sell it then?
Yeah, for right now, I think my data shows that we're going to have about a surplus of about 1 million gallons per day.
Oh, wow.
And there's been talk about...
Rodney, did you write this?
Yes.
How were you able to stay awake?
Yeah, well, it's...
I read this thing. I mean, I have to give you credit for staying awake.
That wasn't
able to
bad.
put this together.
Reading this one...
Oh, yeah. That's bedtime reading.
Yeah.
Yeah.
That's the plan.
Okay, do we have to vote on this one?
Yes.
Okay. Entertain a motion to accept the proposed amendment.
I make a motion.
Mr. Stavropoulos made the motion.
Second.
Mr. Vincent, second. Roll call.
Mr. Chambers?
Yes.
Mr. Galakis?
Yes.
Mr. Ulysses?
Yes.
Mr. Stavropoulos? Yes. Ms. St. Arnold?
Yes.
Mr. Vincent?
Yes.
Chairman Francis?
Yes. Okay, any staff comments, board comments?
Yeah. You want to go first, or how do you want to?
I'd like to go first. I have a couple comments.
I'm sure most of you read in the paper that there was a meeting before the city commission on the 22nd dealing with, membership on the planning and zoning board. And I watched the replay on television. I wasn't there, and I know a couple of you, Mr. Vincent and Mr. Zelakis, were there. And a lot of things were said by the commission and the mayor, and I guess I just kind of want to give you my perspective on the whole thing. For those of you who weren't there in December, it was quite a long meeting. Went to 1:30. The city manager was there. We had 77 people in the audience. Things got heated with some people, and I guess that next day, the city manager's phone was ringing. Commissioners were being called. And they were kind of, I guess the people who hadn't been coming to these meetings and watching on TV were here in the audience in person, and they felt that some of the applicants were treated unfairly and thought that some of the language and the verbal language and the body language towards some of the applicants was not professional. And so, Commissioner Slattery placed that item on the agenda to see if there was what needed to be done. And from what I could tell, I guess the attorney and the city manager may be doing something as far as, I guess, having a heart-to-heart with the board. And I guess, from my perspective, we can always disagree, but we don't have to be disagreeable. You're not going to always agree with me, and I don't expect you to. I expect everyone to have their own opinion, to make their own decisions. What I try to do as staff is be as transparent as possible, lay out all the facts to you, give as much information as I can so you make an informed decision. But I also want to kind of reiterate that, we're all on the same team. We're all working towards the same goal. And all we want to do is, bring good projects to Tarpon Springs. And I know at the meeting they talked a lot about the city and I just kind of let you guys, understand as staff what we're dealing with. I went back and looked over the last 2012. And we had 22 development-related applications that the Planning and Zoning Board reviewed. And I know Mr. Vincent had a comment about not knowing, these things were kind of bubbling below the surface. But I can tell you, I went through the 22 development-related applications, conditional use of site plans, annexations, rezonings. 12 of those, depending on how this meeting goes, over half the time I'll get a phone call Tuesday morning. And you guys won't hear this because they don't, they can't they're not coming to contact you. Either I get a phone call, city manager gets a phone call, or someone else. And I get a phone call and they say things like, that's not normally how it is. That can't be, and it's not just an isolated incident. Like I said, over half the applications that we looked at in 2012, on Tuesday morning between about 9 and 10 o'clock, I get a phone call from an applicant. It doesn't have to be somebody with a big project either. It's a lot of times it's people with a conditional use. It's a very simple application, and they ask me, why was I treated that way? Why was I being interrogated? Why was I kind of put on the spot? And so I think as staff, what we're trying to do is to explain to you, it doesn't have to be such an adversarial process with the applicants. They're coming to the city, and our impression is, our position is, they are investing in Tarpon Springs, and we make sure that they meet the code. Trust me, we do our share of beating them up. We have a site plan in right now that I just mailed out two pages of comments. But we are making sure that they meet the code. So when you guys see these applications, it's our belief that the code standards have pretty much been met. And I think that's all, from what I can understand, that the city manager is looking for is just, consistent, professional decorum and treatment of applicants. Whether, you may think it's a bad project or a good project or it meets the code or it doesn't. We still strive to treat everybody fairly and equally. And I think that's really all that we as staff and as the city are looking for. What you guys I think some of you don't really understand is when an applicant, especially someone who is doing a small project, they don't differentiate me any different than they do you. Even though I'm paid and you guys are volunteers, they look at you guys the same way. And I'd like for you guys to believe that, as well, is that, you guys are part of the city's process. They can't get through to an approval unless they go through you. So, just have that in the back of your mind as you're looking at these applications. Because I think we have a good group, we have a good cross-section, we have some new members, but we also have some members who have been here for a while. If you guys feel that you need more training, the chairman and I have been talking the last couple of months about putting together a binder of materials for those of you who, everybody can need a little continuing education, Well, I still get it. I have to have it.
It's to me, it's an absolute must.
Right.
And we've talked about it, and I think now, hopefully, we can go ahead and get started on that. And I really want to see that done. Because it's gonna help us as fast as we can get the new members up to speed. It's going to help us get through the applications.
Everything stays as I planned it. I should have a draft for you for next month's meeting. But anyway, I know we only got 5 minutes, but Mr. Vincent, go ahead.
Thanks for leaving 5 minutes. I have a number of things that run out of time, but I will address the issue. I did, and so did Peter Delacus, attended this Board of Commissioners meeting, and I left a memo that prompted my attending that meeting. A memo from the city manager. I gave a copy to everyone to see what the issue was if you haven't heard about it. And in his memo, he raised sort of what Rodney is saying, that they've had complaints from the applicants. I was surprised because I hadn't heard any here brought before us, and I expressed that to the Board of Commissioners, that I thought, if there were so many complaints, someone should bring them to our attention and address it. but I will say that I was pleased that the intervener provision of our rules and procedures seems to be working. This is brand new for us. We adopted it in 2011, I think, and this is the first time we really had to deal with it, so it's sort of a learning process that I think well, the second month, it's the same people. I think it's working. I do want to comment, though, I think that our role as a member on this board, like any quasi-judicial board, when we're acting like the judges when we're doing a quasi-judicial hearing. And it's not our role, I don't think, to argue with anyone at that stand. We can ask questions, we can listen to the questions and listen to the testimony, and after the public hearing's done, we can argue among ourselves about the position and why we think it should be one way or another. Yeah. You know, that's where the argument comes in, is among us. But when there's someone there, our job is to ask questions and to listen. And I find it improper for a board member to interrogate in a way that's more adversarial when someone's there. You know, we just need to gather information, and then we're finders of fact. That's what we are, like a jury. When we're sitting here, we listen to the facts that are presented. You know, we have all kinds of different facts that we hear, and our job is to figure out which facts we believe and say this, and by a majority action of the board, this is what we determine. And that's our role, and I think that we need to reevaluate and to stay that, and also to try to stay away from things that aren't that are irrelevant, and just focus on what is relevant to the issue. I mean, there's a lot of interesting things we can learn about, but you know, we really need to consider what's relevant to the issue that we're deciding, and I think it would make the meetings go a lot quicker, and would be more pleasant for everybody involved. One thing, real quick, the word signs. We've heard it tonight a lot, and I was driving through the McDonald's thing, and I saw about a million of these little signs popped up all around, and it just reminds me that, you know, anywhere you go in town, you see all these little signs everywhere, the sidewalks, whether it's SpongeBob, downtown, and why didn't code enforcement do something about it?
They actually, Mr. Vincent, they do. There's only one officer. Matter of fact, she was just down at, where was it? The seafood market on the docks and took one. She has the ability, the code gives her authority to remove those, and she does them as much as.
Well, last time I mentioned it to the code enforcement officer, she informed me that she had been directed by her higher ups not to take action unless there was a complaint. And so even if she sees violations, she's not to take action unless someone calls in.
She's not doing that. No, actually, Mr. Vincent, I show you a copy of the email. She took out Northside Seafood, I think it was, who had a banner up. This was not a complaint. She drove down there and saw it, and she put it in her truck.
I'm glad to hear that.
Yeah.
Well, that's great. The other thing, speaking of signs, I think this business we just heard that's going into where Simple Bites is, you don't need to change the sign at all, just one letter. Instead of B-I-T-E-S, it's B-Y-T-E-S. Simple Bites.
There you go.
So, anyway.
Let me just say one thing. Rodney and I are going to spend some time trying to find some good materials, maybe from the Florida League of Cities or elsewhere, sort of a refresher course on the quasi-judicial process. My experience is that lawyers understand it, but it's just sometimes not intuitive to non-lawyers. And hopefully that will be helpful to you if we can find some good materials. And I'm hoping we can find a video presentation or a CD or something really good by someone who's good at explaining it. I'm probably not, because it just seems so fundamental to me. But maybe I just don't understand why people don't understand it. And so we're going to look for some good material and try to provide that to you, give you as much guidance. And I will take some of the blame for maybe not being proactive in that.
I know we only got probably 30 seconds, but quickly, I don't know if you're aware, probably not, we kind of coin it or call it around the office as we're kind of in a development project renaissance. All of our old incomplete projects, Clifton K, the Banyans, the project on Brittany Park Boulevard, all these are now
Reappearing.
Yes, there are new investors and new engineers, and they are going to start constructing and building out those projects. So,
Which ones are those again?
Mears Townhomes, remember the ones on Mears, 63 units there, townhomes behind Ace Hardware.
Right.
Those are now back in play. Ancoat Bend, the one West US 19, and it's not just those old ones. We have a lot of calls and meetings about new projects. So,
okay, I wanted to ask you about the infill. You know, all these vacant properties, and I know Karen's probably working on this, but you know, it's like looking at the connection between downtown and the Sponge Docks. And, you know, is there something in play there where that area can be,
I know she's actively marketing those areas to her contacts, and it's just a matter of time and market conditions before you see things.
Right.
So.
Okay. Anything else? Anybody? Okay. Motion for adjournment.
Motion to adjourn.
Okay. It's unanimous. Thank you.